The urgency is that, my lord, before my lords, the appellants are, Lord, I have taken an appeal.
What do you want?
My lord, the matter to be included tomorrow, my lord. Why is so urgency, my lord?
It will be included, but we cannot assure you whether we will
My
be
lord, may I indicate what is the what is predicament to me, my lord? The appellant herein, the impugned order, I have not participated. I was not represented. Order passed. There is a direction to pay our enhanced compensation, my lord. Within a specified period, contempt has been initiated against the former chief secretary of the state. I am the government, my lord, appellant herein. The government undertaking body, the Weighable Corporation, my lord. But within a specified period of 3 weeks, my lord, payment has to be disbursed by the state. Now, my lord, 1 week has already been gone because the rule has been discharged for a time being, so that the order can be tested before your my lords. This is the reason, my lord. Otherwise, 2 weeks, my lord, next 1 week. There is
rule discharge. Why your worried?
Because 3 weeks, my lord, the payment has to be made. For the time being, the rule has been discharged. So
against Weighable.
Against the Weighable, the chairman of this, my lord.
You tell the appeal court is insisting of the matter.
My lord,
rule has been discharged. No fresh rule has been.
No, my lord, the DM, because rule has been issued against the Weighable. The states were directed to pay a compensation on being receipt of the money from the Weighable requiring body within 3 weeks.
So, pertaining to what? Land?
Pertaining to land, my lord. So they are not entitled.
3 weeks from which day?
3 weeks from the disbursement of the payment from the requiring body. So disbursement has been made on, my lord, 10th of this month. And, my lord, 3 weeks, my lord, is expiring next week. There is no circuit, my lord. This is my only difficulties, my lord.
Then what will happen if you do not pay?
Then, my lord, if we do not pay,
rule will be issued against you.
Maybe, my lord.
Oh, so then the court will function. What is the urgency?
What
much this expense is sitting?
No, my lord, otherwise, my lord, non-compliance of the order, my lord, will face the DM.
If there is non-compliance, sir, what is the procedure? They will go to contempt.
Yes, my lord.
There will be a question of issuing rule against you. Because you are not receiving the payment from Weighable.
No, the state has already received. I am the appellant.
You are who? You are the state.
I am the state undertaking body, corporation, Weighable, requiring body.
Yes.
Requiring body has made a payment to the state exchequer. Now, the state exchequer shall disburse within a period of 3 weeks to the petitioner, respondent one herein, my lord. So I am facing the difficulties, my lord. After the expiry of the 3 weeks, I have to make payment, my lord, without being adjudicated.
No, payment you have to, you are the requiring body.
I am the requiring body.
So you will send the payment to the state.
I sent.
Very good. You will give the payment to the state.
Yes, my lord.
It has to make it within
3 weeks, my lord.
If they do not issue within 3 weeks,
yes,
then rule will be issued against the state, not against you.
No, not against me. Then, but, my lord, if the payment is made, my lord, my adjudication, my lord, in my absence, before the London district judge, I was not made a party. Before the read court, my lord, I was not represented, my lord.
Don't find any action. Yes,
my lord, kindly.
Lordship,
Copy it now. It will be. Yes.
Lordship, may I be permitted to mention a matter, Lordship? Lordship, may I be permitted to mention a matter?
Order 41/11, your lordship was pleased to update the matter under the heading mentioned matter. But, my lord, it is my lord, in the.
What can we do, madam? We cannot upend your second appeal is along with the which one you are saying that which you have mentioned.
These two matters
let us see. We cannot assure you.
Lordship, may I be permitted to mention a matter, Lordship?
What? There is a section 5 in your set. There is a section 5. Which matter are you mentioning?
Eviction soon, my lord. I have the time, my lord, only today. I have the up to today, lordship. I have the time in my hand, lord. My lord, although, my lord, there was a direction notice in order 41.
Which one was your matter?
71. My matter 71.
In your matter, was there any direction that the other side will be heard before it appeared before judge?
There's a direction to serve notice. This matter was filed by your lordship on the very first day of this circuit. My lord, that day, my lord, nobody appeared. Also, the services affected.
Let us see, madam. Let us see how we proceed, please.
Lordship.
My lord, vacate the my lord suit premises, lordship. Any time, my lord.
Execution is running. Execution is.
What execution case filed?
execution, but they are not appearing here.
No, don't let them not appear. Execution case, when is the next day?
I have that.
Show us execution. Please collect it and come. Yes, call the
My lord,
list.
at least it is
Lordship,
appearing.
may I be permitted to mention one,
It is
Lordship?
appeared in the list.
Lordship, yes.
Lordship, Lordship, there is an urgency, Lordship, a mandamus appeal, Lordship.
Let us see, Mr. Poddar, how do we proceed? Yes, yes, call the list.
Lordship, may I be permitted to mention one matter,
Subject to
one
your
last
lordship,
matter.
subject to your lordship,
Lordship,
can sanction note, at the risk of repetition, may I mention item number 83, days list, your lordship.
Miss Maiti, we
My
have
lord, your
collected the matters. We cannot assure you whether we will reach or not. Please.
Yes, my lord, that is why, my lord, I did not mention for 2 days, my lord. Today I am taking a, my lord, before your lordship, my lord, indulgence. So that, my lord, my matter will take 5 minutes time, my lord. Your lordship, otherwise, my lord,
Maiti, please,
my
we have hard
application will become infructuous. My application will
Lordship.
become,
Lordship, may I be permitted to mention one matter, Lordship?
Which matter? Which matter you are mentioning?
Lordship,
Which
there's a
matter?
mandamus. Lordship, I'm mentioning a matter, a mandamus appeal along with a stay petition, Lordship. The crux is
Is it in the list?
on 12th of February, Justice. It is not in the list. For inclusion in the list, I'm mentioning the matter, Lordship.
You
There
send
is a
the slip,
specific
it will
direction
be-
to file to
Send
give
the
rupees
slip,
10 lakh
it will
rupees.
be in the list.
Lordship, this is the
Send the slip,
Grateful, Lordship. Grateful, Lordship. My brother colleague is there. He'll serve it, Lordship.
which is where is your? Achha, theek hai.
Lordship,
Yes.
he is there. Mr. Shankar Sarkar is there.
Yes.
Listen, my lord, in this matter, my lord was placed to grant a claim on 18 February 2025. There is a small correction which needs to be made. My lord, in the page 2, paragraph number 3, it has been written that to the satisfaction of the learned vacation judge Shiliguri. Instead of that, it need to be made that the additional session judge first for Shiliguri.
Write it down.
Yes.
Yes. Give it. Give it. By reason of a typographical error in the fourth paragraph of the order dated 18 December 25. It was directed that the petitioner shall be released on bail upon furnishing a bond of rupees 10,000, which you are likely each one of whom must be to the satisfaction of the by reason of a typo in such and such paragraph. It was directed that the bond is to be furnished to the satisfaction of বলে কোট আনকোটে লার্নেড ভেকেশন জাজ কমা শিলিগুড়ি in place and stead of যেটা উনি বলছেন office is directed to effect necessary correction. Stop. The other portions of the order shall remain unaltered. Yes, next.
Matter was hard earlier by your lordship that a charge sheet filed without FSL report, we have relied some judgment money. We are praying for statutory bail, my lord, because the charge sheet has been filed without FSL report and there was no prayer for extension. On that regard, we have referred some
In the charge sheet, it was when was the charge sheet filed? That charge sheet,
Charge sheet was 12th of December 24th.
12th of December 2012.
24, hai.
12th of December 2024.
Huh.
180 days was expiring on
on send
On 12th April,
before the statutory period.
that is on the date of expiry of the, so it was within time.
Within time.
Within-
But it was without a
Yes, sir.
statement that with leave to file supplementary evidence.
No,
That
that
was-
is
that was-
he is there.
Where you have written in the charge sheet?
There was no extension and so for the observation.
That was not incorporated in the charge sheet. Which paragraph you have stated so?
My lord, it is task of my lord.
Paragraph in your petition.
My lord, here in the charge sheet is written that after we get the FSL report, we'll be filing the supplementary charge sheet.
My lord, can you see the
Last paragraph of the
my lord,
charge
can you
sheet.
see the paragraph number 10 of my application?
The result has been implemented as an interim review followed by after. Yes, where is your application for extension of time?
No extension not there.
There was no extension.
My lord, can you see the paragraph number 10 of my application?
Yes, your bail application was turned down when?
On 13th December, because
My lord,
12th December was 12th December was Sunday, on the 13th December we have filed.
Where is your file?
Well,
Bail?
I have the order which is under challenge.
That is 16th of December.
16th of December, because 13th, 14th was closed. On 6th, on the first working day, we have filed the bail application.
13th, 14th was closed. Why?
Monday, Saturday,
And 15th,
15th was the sealed work in the London work. The demise of one lawyer.
where you have stated all these things? And when did you apply for bail?
My lord, I have filed a put up. Can you see the order dated 16th, 12th? Filed a put up.
14th and 15th was holiday.
My lord, 14th and 15th was holiday.
16th কি আছে?
16th is petition.
And 13th?
13th is petition. তো 180 হয়নি। 14th to 180
The failure on the part of the prosecution to include the FSL report pertaining to the seized contraband articles along with the charge sheet in the time specified for section 2024. The plain just for matter is pending before the honorable apex court.
তাহলে এখানে কি
But
করলো?
no,
যে bailটা
up to
দিল?
the lordship's concern, but no stay work here.
Like an interim bill or extension child, এটা ওই করলাম আর কি।
No extension was there as per section 36A subsection 4.
That was the issue raised before the honorable apex court.
My lord,
That is
but
That is
there is
referred-
pending.
pending.
There is pending one. No stay was granted by the honorable apex.
No application was filed for extension of the
Well, charge sheet was filed, na, so
charge.
that is the
So
charge sheet.
not required.
Not required.
The interim supplementary charge sheet was by submitting supplementary charge sheet
Result
of the investigation has been intimated to the complainant as an interim intimation followed.
When did you intimate the complainant? Your investigating officer, Raban Sarkar,
My lord,
with this bold letter portion you are referring to. Witnesses as noted in such and such, the result of the investigation has been intimated to the complainant as an interim intimation, followed by after submitting supplementary final intimation. Where is the intimation given?
to the
To the
accused.
complainant?
A complainant. Complainant is it's a police officer, I think.
Complainant was the police
My
officer.
lord.
Who lodged the complaint?
So much the complaint.
So modo by the
One of the police personnel lodged the complaint.
So where is this intimation, Mr. Chakraborty?
my lord, I have to then check, my lord. Just a minute.
বিলটাকে already কিছু বলেন? সেটা কি আপনি দেখেছেন?
It's a default bill ছিল।
কোন ডকুমেন্ট আছে সেটা অরিজিৎ রেফার আছে, অরিজিৎ রেফার আর দোজ 2010 আর এটা তখন this was not shoot to origin, this was
রেফার হয় না।
নামটা কি জানি?
এটা হচ্ছে আনিপান সারি ভার্সেস স্টেট অফ গভর্নমেন্ট অফ এনসিটি অফ দিল্লি।
Oh, my lord, the result of the result of investigation is that, my lord, the charge sheet has been filed, that has been intimated to the superior, to the complainant, that charge sheet has been filed, and to summon the witnesses. So that has been intimation. That intimation was made
No, to the complainant.
complainant. So that intimation is it has been intimated, whether it has been written or not, my lord, because he has been intimated.
Down conflict of obligation also placed for interim bail at this stage. Once the point of brought to the interim bail case has not signed.
অরিজিতের জাজমেন্ট আমরা ফেলে দেবো।
According to the judgment that
কিন্তু কোর্ডিনেট বলছে এটা on that there was no clear for bail. So Mr. Chakraborty, what do you say about this judgment?
The judgment though is still pending before the, oh my lord, this one.
This judgment? Why should we divert from it? What was the recovery?
Yes,
24 kg, sir.
24 kg. You're the sole accused. You also did not, your put up petition was made for what? Statutory bail. Where do you have given that?
after filing of charge sheet.
My lord, this judgment period over 30. Certificate 180 days.
Well,
after filing of first charge sheet, he filed an application for default bail.
Yes,
Default.
after filing of charge.
14th and 15th were holiday. On the 16th, that is relying the section 10 of the
On the
general.
ground
within
that
3 access-
on the ground that no prayer for extension was made by the investigating
By-
officer. That is the ground that the officer.
ওটাতে extension আছে, আমার application করতে হবে। FSL ফাইল করবো,
Or supplementary charge sheet.
সেটা তো কোর্টকে বলে দেওয়া to take the call.
Exactly.
The fact that you will file a supplementary charge sheet, that has to be made known to the court by way of an application that extend the time.
No, already it's in the, when we file the charge sheet, it's in the prayer in
No,
charge.
no, Mr. Chakraborty, you have to come with an application to the court. It's a statutory bail.
That has been not been done. Well, the thing is that when,
No, so it is an admitted fact, you did not pray for any extension of time.
no,
So in said backdrop, 36A will apply.
but when a charge sheet to was filed. na.
Cortex my lord, I have to draw the credential.
Wait, we are asking him.
Whether
Yeah,
charge sheet was,
asking.
whether charge sheet was filed, first charge sheet was filed within the stipulated time.
Yes,
When was the first remand?
That is the first.
180
case started,
days.
my lord, he was arrested on spot 16/6/24.
Without FSL report.
No, my lord.
No, no,
First, that is the first event,
So 16/6,
2024.
He was arrested,
so he was produced on 16th of June.
June, my lord.
maybe on next day 17.
No, no, 16th of June.
So from 16th of June, 180 days takes us to which date?
13th December.
You're sure?
Charge sheet has been filed on 12th December. 14th and 15th are holiday. On the first opening day, relying the preposition of the section 10 of the General Causes Act, we filed a put up. So the last working day will be the next working day. As the 181 days when hits, then those days were holiday.
Now, we thought, there's no question of filing of statutory bill application before expiry of 180 days. So we have filed the charge sheet within 180 days.
Along with the charge sheet, you ought to have filed an application. Let us see 36A.
My lord, yeah,
That is it, A subsection 4, my lord. Now, my lord, may I submit one thing, my lord?
90 days. One, একেবারে বই না। Where they are in, there's one is not written here. If I can also found in social media,
On the application.
on the report of the indicating progress. এটা কোনো indicating progress বলে দিয়েছে supplementary আমরা file করব।
How many words are needed?
Actually, my lord, rather filing this charge sheet, they could have filed an extension petition that FSL has not been received. Because from 180 days, it can be extended up to 1 year, 365 days. So without doing that, without the FSL report, they have filed the charge sheet with a prayer for submitting supplementary charge sheet after they get the CFSL report.
Not complicated.
তারপরে কিছুদিন পরে CFSL রিপোর্টটা ফাইল করে দিল। তো 11 দিন ফাইল করতে
হ্যাঁ, your investigating officer creates the problem.
Madam, may I submit one?
No. Yes, what's happening?
Subject to lordship correction. On judgment I have filed for the dear lordship, there is the honorable court and it's the page number 14, my lord. The identical situation.
Then why you are placing? What identical?
Well, Para 14.
This you have already given, we are considering. Ashun. Mr. Bhumik, learned advocate appearing for the petitioner submits that the petitioner was implicated in connection with NJP GRS police station, GRPS police station case number 45/2024 dated Petitioner, 8, next circuit, 8,
Item number 9.
yes.
Actually, I'm for the petition.
DSU will appear virtual.
Yesterday the matter was part heard and
Just remind us,
Lordship, that matter, that rustic village lady, the housewife was arrested. The husband, there was a conversation whether the husband can be surrendered or not, then DSG.
Oh, acha, acha.
That matter. So I'm doing the hearing. Because lastly, yesterday, my lord told that quote unquote, my court is not directing me to.
No, no, we shall not.
So I'm going into the facts.
Yes.
First of all, Lordship, may I take Lordship to page 20 once again?
Yes,
Page 20 is, Lordship, first, the
the raid was conducted
by the BSF
BSF team
on,
on,
I'm coming to it, Lordship. This is the compliance report when the matter was handed over to the NCB. They have given a compliance report to the superintendent, Narcotics Control Bureau, Siliguri Zonal Unit. Kindly says, Lordship, second paragraph, 6th line.
yes, there,
Thereafter, the BSF team approached the house, and one woman was present there, and searched the target house of Mr. Vakil Burman, that is the husband of the petitioner, son of such and such, a village such and such, under PS Sitai district, Kujvihar. The woman present in the house introduced herself as the wife of Vakil Burman, Srimati Shurobala Burman, aged 40 years, who was present in the house. So the BSF found the petitioner present in the house, being the wife of the person, Vakil Burman, whose house was targeted by the BSF. Now this is clear, Lordship. Now secondly, I take your Lordships to page 11 of my petition.
yes.
Lordship, this is the
So
production.
when was the lady produced? After she was arrested when?
She was arrested by the BSF on 30th.
Any arrest memo was drawn?
Nothing. I'm coming to the Lordship. This is the 167 petition filed by the NCB while producing. This is forwarding letter. When the victim, when the accused was arrested,
Yes.
and produced before the
On 1st of June.
Lordship. Now, first paragraph, kindly see first paragraph. That was on specific input such and such.
No, if the intimation has been given on 2nd June, how the petition says date of first production is 1st June?
The first June, the NCP produced the accused before the jurisdictional court.
After he was handed over by BSF.
By BSF to.
So BSF said that they are handing it over on 2nd June.
But I'll come to it. On 1st June, it was handed over.
But in their letter, they have they said in page 20 anywhere that he was handed over to NCB on 1st June.
This is NCB document, Lordship. Yes, Lordship. Last paragraph of letter dated page 20.
Yes, last paragraph.
On 1st June, around the information was received by NCB.
Yes, all right.
From the BSF.
So he was placed before the NCB on 1st June.
1st June, after the information was received on 7 hours, and in the afternoon, he was handed over to the NCB by the BSF.
Information was at 3:35 45 hours. So she was arrested and handed over to NCB on 1st June itself.
Arrested by the NCB. No, BSF on 30th. I'm coming to that. Page 11. Page 11, first paragraph.
Yes.
This is the forwarding report of the NCB, where it says, aforesaid house, first paragraph, last line, address on 30/5/2024 under section.
That is the date of seizure.
No, Lordship. The BSF went to the house of Vakil Burman. Can you read the entire paragraph number 1 of page 11? That on specific input, the officer such and such regarding huge stock of fentanyl in a house of village such and such, BSF team 75 battalion seized such number of fentanyl cough syrup. The house premises of Shurubala Burman, wife of Vakil Burman, at the aforesaid house address on 35/2024. So BSF raided the house on 35/2024. It is their document, not mine. And BSF handed over the accused along with the contraband articles alleged on 1st June 2024.
Where do we find that?
Lordship, page 20, last paragraph.
Very good.
Now, Lordship, kindly comes to page 13.
Yes.
This is the BSF Caesar memo. Kindly sees the date.
This is again on 31st.
31st. So on 30th June, as per their case record, the accused was taken to their custody without any arrest memo. The contraband articles were seized. On the next date, and the 31st, the Caesar memo was prepared. This is their document, Lordship. This much is clear from here. Now, Lordship.
Raid was on 30th of
30th
May.
June.
She was arrested without any, there was no arrest memo.
No arrest memo.
Then thereafter, she was handed over to NCB on
On
1st of June, though the Caesar list was drawn up on
31st.
Very
Now,
good.
Lordship. Page 15. Page 15. This is the gist of information received by the NCB from the BSF. Lordship sees the gist of information today at 1st June 2022 at around 7 hours. So, information received by Gulshan Kumar, Sub Inspector, NCB, Shiliguri. So, NCB steps into the shoe of the BSF not prior than 1st June 2024. Now, kindly turns up the page to page 16. This is the memorandum of arrest by the NCB. NCB. Now,
Formal arrest was on 1st June.
1st June.
So what is the problem there?
So, a person who was apprehended on 30th by the BSF without any arrest.
Not arrested.
Not arrested. Can a lady be apprehended and detained in the custody for 2 days?
We don't know whether she was detained.
I am coming to that.
Yes.
The NCB says on 1st June, they raided the BSF office, 75 BSF. They went there. The seizure was made there. And they took the lady to their custody. I am coming to that. First, Lordship, this part, or page 16, middle portion.
Yes, we have seen Caesar, memo of arrest.
Memo of arrest.
So
that is it. Now, Lordship, page 17. Page 17. This is the search cum Caesar list. That is re-Caesar by the NCB. Now, Lordship, after where from recovered, there is a line and then come. Search started at BOP Shitai of 75 Battalion BSF 1145 hours on 1st June 2024 and completed on 12:30 hours on 1st June.
No, their cases we arrested on 1st June, we produced
on 1st June. I'm not on NCB, I'm on the BSF part.
So BSF, that portion that violates your fundamental right.
Right.
How that can be tagged with this arrest?
I'm coming to it.
How that you can proceed against BSF that why did you keep me under your...
Now, Lordship, kindly consider one point. If a person is detained, because this arrest is the continuation of the earlier.
Follow up
of that. A person without an arrest memo, if...
Where is that line that the accused was handed over to NCB?
That arrest,
by BSF.
Arrest memo of No, from where?
In consequence connection, such and such case in recorded sections we arrested. Finish.
Now page 20 says, page 20.
So there is a gray area as regards 30th May to 31st May. That you are saying that was an illegal detention by the BSF.
by the BSF, which
But
which
how
one-
does that help you in bail application?
I'm coming to you, Lordship.
Yes, yes,
Okay.
tell us first.
This is one ground. Another ground is that, Lordship. Page 22. Page 22.
20, yes.
This is the final complaint, that is charge sheet.
Huh.
Now, kindly see paragraph 2.
Yes.
Paragraph 2.
Huh.
If Lordship sees paragraph 2, Lordship will find that
1st June.
1st June, the NCB has taken the possession of the accused from BSF, everything.
Where is that line? That
Lordship. That on information received.
No, Mr. Ganguly, Mr. Ganguly, suppose assuming you are right, then she was under illegal detention from 30th May till 31st of June. So that illegal detention, can it be a ground for your bail in this matter?
Lordship, it can be. As because, Lordship, I am
And what other ground you are referring?
I'm that. Now, Lordship, kindly sees page 25, para 6.
Yes.
It is regarding 67.
Hmm.
Kindly read, list, Lordship. May I read it? That thereafter, notice under 67C NDPS Act was issued to Surubala Burman by the present complainant for recording her statement. In her voluntary statement, Surubala Burman disclosed that she, along with her husband, Vakil Burman, is involved in illegal business of fentanyl, cough syrup. Her husband, Vakil Burman, is a farmer and also drives an e-auto for living. On the other hand, she is a housewife and does not do anything for her earning money. Her daughter is married and stays at Malbazar, Jalpaiguri, and her stays at Siliguri. Vakil Burman has some local friends associates who are also involved in the illegal smuggling of fentanyl cough syrup. However, she did not disclose their name, address, and contact details. She was not aware from where Vakil Burman got this confiscated consignment of fentanyl. This is important. She was not aware from where Vakil Burman got this consignment of fentanyl, and she also did not know whether her husband has any valid license for dealing the pharmaceutical drugs. Now, may I hand over the statements? The copy has been given to us. The statements. Lordship does not find any line that here it is mentioned that she, along with her husband, is involved. She admitted. There is no admission to that effect. On the contrary, Lordship. Lordship, on the contrary, twice this statement was recorded on 3/6/2024 and 4/6/2024.
Where is that she admitted?
Lordship,
Voluntary disclose, she along with is involved in the business.
now the statement is before your Lordship.
Yes, which portion?
There is no statement to that effect. Two statements are there. On the contrary, here from the statements, Lordship will be, I can apprise Lordship that she is a LTI. She is a illiterate rustic village lady, does not know anything. It is from there. And the case of the prosecution that the actual culprits are the husband, friends of the husband. The question has been put. Kindly see, Lordship. Question number 3 on 3/6/2024. আপনার স্বামীর বন্ধুরা যারা এই অবৈধ ব্যবসার সাথে জড়িত তাদের নাম কি, তারা কোথায় থাকে আমি জানি না।
That is there in page 20.
Yes, Lordship. But that portion that she along with her husband admitted that they are in the business, nowhere it is there. On the contrary, if Lordship transfer the page, the statement recorded on 4/6/2024. The question, আপনার বাড়ির জমির মালিক কে বা
Each question.
Question number 1, আপনার বাড়ির জমির মালিক কে বা জমির বাড়ির দলিলপত্র কার নামে আছে? উত্তর, আমার সঠিক জানা নেই। 2 নম্বর, আপনার জমির বাড়ির দলিলপত্র কোথায় আছে? আমার সঠিক জানা নেই, আমার স্বামী জানবে।
So there is this contradiction between recording and the actual statement given.
Regarding that
Her involvement.
that she confessed, it is not there. On the contrary, Lordship, the whose name the land is there, she says আপনার বাড়ি বিদ্যুৎ সংযোগ আছে কিনা, থাকলে কার নামে? আমার স্বামী উকিল বর্মনের নামে আছে। বাড়ির বিদ্যুৎ সংযোগ আমার জানা নেই, আমার স্বামী বলতে পারবে। So she is a Lordship, on this ground, Lordship, I am banking upon the conscious possession. A judgment of Lordship passed on to 2025 itself. Instant judgment, para 21. May I read, Lordship? Conscious possession refers to a scenario where an individual not only physically possesses a narcotic drug or psychotropic substance, but also aware of its presence and nature. In other words, it requires both physical control and mental awareness. In this case, Lordship, if I pause, that he knew that those contraband are in the house. She had the mental awareness, whether she had physical control over the business. Because it's the question of the put by the NCB that her husband friends who were involved in the business, she doesn't know their next, Lordship. The concept of evolved primarily through judicial interpretation, since the term conscious possession is not explicit.
My lord, what judgment Mr. Ganguly is reading out? May we get the citation?
2025 SCC Online Supreme Court 122. Two
I
judges
don't-
bench before Justice Honorable Justice Padriwala and Mahadevan.
Please give me the name of the case. I will try to find it out.
This is Rakesh Kumar Raghuvanshi versus State of Madhya Pradesh.
Yes, what do you say?
Lordship, has he finished?
Yes, finished.
My lord, because if I start, he will start interjecting.
What?
He has finished. My Master Ganguly has finished.
Lordship, one thing, to sum up, neither the BSF nor the NCB has conducted search and seizure before in presence of any executive magistrate or independent gazetted officer who was not a part of the
You
review.
are in custody for how much?
Lordship, I am in custody. Lordship, 265 days.
Charge sheet submitted? No.
Charge sheet submitted, copies supplied, but trial cannot commence as because other accused persons are absconding.
नाम बनेगा स्टेट ऑफ
When we come to the question 4 of this one,
Question 4 of
that statement.
আপনার আগে এর আগে কবার আপনার বাড়িতে ফেন্সিডিল কাপ সিরাপ এসেছে? একবার মাসের শুরুতে, ওটা বিক্রি হয়ে যাওয়ার পর এটা ঢুকেছে 30 তারিখে. She had the knowledge that those articles were kept and it was sent.
Yes.
But my question is,
My lord, 12,000 bottles of Fencidil.
I have not completed.
Everybody.
Yes.
My question is, she knew that those articles were there and it was available, but whether she had the control over the business, because it is the question put by NCB that husband and the friends who are involved in the business.
Very good. But this consciousness, how can we eradicate at this stage? Tell us, Mr. Ganguly.
My lord, by giving her Fencidil to drink.
Lordship, at least the arrest made by the BSF without any following the procedure.
That, Mr. Ganguly, is a question you can appreciate.
Lordship, the Supreme Court says that if the initial arrest is vitiated, the trial is vitiated. Supreme Court says this is also 2025 judgment.
How the initial arrest is vitiated?
No,
They arrested on 1st June.
So how can they detain the person without being arrested to their BSF barrack for 2 days?
That is for you to take up appropriate proceeding against BSF.
I am before my lord not considered, because this subsequent arrest is the follow-up of that earlier. If that is illegal, any follow-up is illegal.
Yes, finish. Yes, what is
Lordship, first of all, my learned friend is mistaking one in one place. BSF cannot arrest a civilian. He can be detained in proper custody with lady constables, as in this case. BSF has no power to arrest a civilian. My lord will find this tangent way of submission whenever NDPS bills are coming. 12,000 bottles of fancy drill. The lady knew what is happening. If she had no knowledge, if she was so naive, how could she direct the BSF team to go there? And my lord, I take your lordship further. Supreme Court has held that even the absence of possession of narcotics in a commercial case, Nawaz Khan's judgment, bail cannot be given. 37 bar is there. Khaliluddin, my lord, says that Supreme Court, all Supreme Court says even the co-accused statement is sufficient to refuse bail. We are on bail, we are not trying the person.
My lord, the BSF ought to have been placed the accused before the police within.
My lord, he doesn't know the procedure of
As per the
BSF.
procedure,
BSF informed
They cannot
police
detain and for 2 days.
Mr.
and
Ganguly, please,
their own
when you
person.
submit it, this is the
It's
problem,
illegal.
my lord. Whenever I start speaking, they
When there has
interject.
been a seizure from the house, what these contradictions which you are pointing out, this is a question to be thrashed out at the appropriate stage.
Then, Lordship,
Today, suppose we grant you bail. The principal accused is not in custody.
No,
Principal, the fact scenario has to be understood. It is
that was the
NDPS.
reason, Lordship, yesterday.
No, but we cannot tell you,
That
Mr.
is the
Ganguly,
thing.
the option is upon you. You can say, all right, give me an adjournment, I take an instruction. That is one way of saying. We cannot tell.
Yes, no.
Mr. Ganguly, you ask your, which we mistakenly may have made an observation. That we cannot
No,
say.
Lordship.
Because I personally, I had a an incident which came to me when the matter was being heard. The State Council said, my lord, we are going to file a supplementary charge sheet. Keep it, today is Thursday, keep it on Monday. So we believed the council, we kept it on Monday. The junior came running to us and said that, my lord, on Monday the matter is appearing, but he has already been arrested. Anticipatory becomes infructuous. So we thought that we are helpless, very express to the council. So we had to convert it to a 482 and we are 439 and give him bail. Now, we cannot say, Mr. Ganguly, it is for the advocate to design the process. That is your advice to the client, that if you can do so, we can persuade the court to, as she is a lady, she is a lady, we can persuade.
Even the law, Lordship, puts lady in a different footing.
Yes, after
Mr.
selling
Ganguly,
12,000 bottles of
advocate
fancy
appearing
drill.
for the petitioner submits that the petitioner has been falsely roped in the present case. There was no recovery of contraband substance from the petitioner. From the possession of the petitioner, the recovery and as such, she had no physical control or mental awareness as regards the contraband substances. In view thereof, the regards of section 37 of the NDPS shall not apply, are not attracted, and considering the fact that the petitioner is a lady member of the family, and as there is no possibility that she would flee from justice, she may be enlarged on bail, as she has already suffered incarceration for 265 days, and upon completion of investigation, charge sheet has been submitted.
Can you consider only para 40 for once, for my satisfaction, Lordship? I humbly submit. As there was no arrest memo or the accused was not placed before the police under section 57 as per the procedure laid down in the CRPC. So no, 14, Lordship. So no ground of arrest was shown. Now para 14 says, para 14, Lordship. Thus, the requirement of informing the person.
Para 14 of what, my lord?
I'm coming.
Now, give me the page number, Mr. Ganguly. I only want to follow your submission.
2025 SEC Online Supreme Court 269.
I don't have the judgment.
Bihan Kumar.
Yes, para 24.
Para
You're
14,
reading.
14,
Yes.
14 Lordship. Thus, requirement 14 Lordship. In requirement of informing the person arrested of the grounds of arrest is not a formality but a mandatory constitutional requirement. Article 22 is included in part 3 of the Constitution under the heading of fundamental rights. Thus, it is the fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as may be after the arrest, it would amount to the violation of fundamental rights of the arrestee guaranteed
Yes,
under
yes.
Article 22. And last line, once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second. I was arrested, but no arrest memo was.
Who denies it?
Lordship?
Who denies it?
Then
Who
that
denies it?
has not been followed, Lordship.
My lord, may I be
The
informed
lady
about
was
one?
detained
In
without arrest
support
memo.
of his arguments, Mr. Ganguly, reliance has been placed upon the judgment delivered in the case of Rakesh Kumar Raghuvanshi versus State of Madhya Pradesh, reported in 2025 SCC Online Supreme Court 120. He further drawing our attention to several documents in the annex to the application. Mr. Ganguly argues that the petitioner was intercepted by the BSF authorities on 30th May 2024. 30th May 2024, and she was illegally detained by the BSF authorities for 2 days and handed over to the NCB authorities on 1st June 2024. As the initial arrest itself was illegal, any arrest made subsequently by the NCB authorities also cannot stand. In support of such argument, such illegal detention tantamounts to violation of the constitutional right or fundamental rights of the petitioner. In support of such contention, reliance has been placed upon the judgment delivered in Rakesh Kumar in Rihan Kumar versus State of Haryana and another reported in 2025 HCC Online Supreme Court 269.
18th of March. 18th of March.
Mr. Mujumdar Learned Advocate BSP appearing for the NCB authority submits that BSF authorities have no authority to arrest.
Lordship, no authority to arrest a civilian.
No authority to arrest a civilian.
And my lord, may I be permitted one line, my lord?
Mr. Ganguly drawing our attention to the statement of the victim, statement of the petitioner as recorded and supplied, and the
What's
complaint. Mr. Ganguly submits that there are blatant contradictions in the said documents, which goes to the root of the matter. And and vitiates the entire prosecution case. Mr. Mojumdar submits no arrest a civilian. He further submits that contraband substance. He submits that how many bottles?
12,000.
12,000 bottles of contraband substance was recovered from
12,773.
12,700 was recovered from the residence of the petitioner. And from the statements made, it would reveal that she had knowledge that contraband substance was being stored in the house. The the husband of the petitioner is still absconding. Husband of the petitioner and his other associates are still absconding.
And warrant issued here.
And warrant of arrest had already been issued. In the said conspectus. The petitioner's application needs to be reviewed. Also, we have heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. It appears that the petitioner was arrested by the NCB authorities on 1st of June 2024 upon drawing up a memorandum of arrest. Stop. Upon drawing up a memorandum of arrest. Stop. The statements of the petitioner. From the statements of the petitioner, prima facie, her involvement in the alleged offence cannot be ruled out. Stop. The regards of section 37 of NDPS Act, in our opinion, are attractive. Stop. Considering the nature of acquisitions and the extent of complicity of the petitioner in the alleged offence, we are of the opinion. We are not inclined to exercise discretion in favor of the petitioner at this stage. Dismissed. Yes, next.
Grateful.
Grateful, Lordship. Lordship, BSF Act says BSF can arrest civilian in 3 types of offences: Passport Act, Custom Act, and NDPS Act. This is,
Nobody can force us to arrest Mr. Ganguly. Please try to understand.
Yes.
Keep on going. And my lord, since he is dragging, Bihan Kumar is a misplaced judgment.
Number 8. Yes.
May I make one indulgence regarding item number 8, my lord? My lord, I have the court number 3, my lord. Kindly pardon me and take up the matter. Next,
Kept it in the next circuit, sir. Yes, item number next 11. Yes, 10. Who is in 10? 10. Who is there?
I am for the statement.
Yes.
Madam. Page number 11, Caesar list, madam, on 30th May 2024, madam, page 11. Madam, seized from 2 accused persons, out of whom petitioner is 1, madam. Madam, 44 bottles of cough syrup.
You are Vikas Das.
Yes, madam.
Vikas Das.
CFT capsules and 44 bottles of cough syrup. CFT numbers of capsule with its natural substance like paracetamol and dicyclomine comes to 146.3 grams, which is below commercial quantity, madam. And 44 bottles of cough syrup falls under the commercial quantity, madam. Page number 13, madam. The charge sheet, 31st October 2024, madam. Charge sheet has been submitted against 4 accused persons, madam, and out of whom, madam, can you see page number 17, out of whom 1 Sushila Guru is absconded, so there is no possibility the immediate commencement of trial, madam. My lord, now kindly see page 19, that is the whom the seizure was made, the 4 accused persons has enlarged on bail by this honorable court, my lord, on 30th August 2024, and my lord,
Ranjana Das, it was seized from Ranjana Das,
yes, my lord.
only shown and produced by Vikas Das.
Allegedly.
My lord,
Court of Supreme.
para 2, my lord. Para number 2, the order sheet.
Ranjana Das is
The wife of this Vikas.
Yes. Now Ranjana Das has been given bail.
Yes, my lord. As because, my lord, para 3, my lord.
My
Counsel for the state.
in the charge sheet, so there in the memo of arrest, my lord, can you see page number 12, my lord? The column 10, that is Rohan Das, name has not been mentioned in the season list
as well as charge sheet as a
Rohan,
witness.
who is Rohan Das?
My,
Independent witness, my lord.
What you are
not
saying?
even charge sheet, not even complaint, not even Caesar list, my lord, as a witness, my lord.
Not mentioned as a charge sheet witness.
Charge sheet witness and Caesar list and not in complaint, my lord. My lord, I am relying one judgment, my lord. That is the, my lord, can we see? My lord, charge sheet, Caesar list, and the name has not been mentioned in the memo of arrest name. Rohan Das, my lord. And my lord, I am relying one judgment, my lord, on these meetings. Please see. In March, my lord, Bishop. That's Bishop. You agree with this judgment. Can we see? My lord, para 4. My lord, undoubtedly, learned counsel for the prosecution is justified in submitting so. However, we find from the memo of arrest that Monindranath Borman has rightly pointed out by the petitioner was the purported independent witness who signed the memo of arrest, whereas his name does not find place anywhere else yielded as a witness, my lord. My lord, on this ground, my lord,
Witness has in the charge sheet.
in the charge sheet, in the has not been as a witness.
All right, madam. Yes, yes, what do you
My
say?
lord, in their annexure, page 19, my lord, para 2 and 3. The order sheet of the coordinate with para 2 and 3.
Housewife given.
Housewife given, and he is the husband, he is the principal accused from his conscious possession.
Now, what do you say about this?
Rohan Das,
witness?
at the time of trial, at the time of taking evidence, under section 311, we can,
Witness, my lord.
under section 311.
Why he should not be called as a witness? What has power?
Under section 311
What
of
is the
the
law?
CRPC,
His
Section
name
is there.
and
Yes.
my lord, the witness, namely Rohan Das, in the arrest memo does not find its place and
Then the prosecution case will fail, madam. They won't be able to prove them. It's a matter of trial.
arrest is dispute, my lord, and
You are the principal accused.
my lord, co-accused has enlarged on will remain in 58 days custody, my lord, and I am in custody in 266 days, my lord.
my lord, there is
Arrest is dispute, my lord.
para 2 and para 3, my lord. All in the annexure P2,
My lord, see
page
his charge sheet,
19.
my lord.
He is the principal accused.
Ms. Chakraborty, learned advocate appearing for the petitioner submits that the petitioner
Lordship, I am for the petitioner. Yesterday, Lordship, we had made the argument, advanced the argument, stating that the petition of complaint says that I have
that arrest.
I have been arrested in a particular date, particular time from a particular place. But our CCTV, that is the CCTV collected by us from the opposite of our house, we have submitted the CCTV also. Kindly sees the picture.
Contradiction, Mr. Banguli, why should we address at this stage?
Lordship, if it is seen that the accused, I'm only one point, Lordship. If it is seen that the accused was arrested by the police on 25/11/2024, Monday at 3:00.46 hours. Kindly see the photographs. I have mentioned the time. The time is mentioned in the photographs, Lordship.
My lord.
Yeah, yeah. 25?
Lordship, the photographs.
Yes, that time does not tell you.
So if I was arrested from my house by the police on 3 a.m., how can I be arrested by the police at 12:35 hours at a different place?
Arrest memo is at page?
Lordship,
My lord,
arrest.
page 37 of the CD. I have given the CD. My lord.
You will go to the CC. Arrest memo is here in the 37.
My lord, first, my lord, before my lord goes, this is, I'll show my lord page 25, my lord.
Yes.
My lord, what happened, my lord, even at the time of search and seizure, the videography was done. That is in page number 25, and we have already enclosed the CD. The IO is present, my lord, the clip of the videography where the search and seizure was done. So now what they are showing that there was some timings and all, these are subject to, my lord, all verification at the time of trial, my lord. We have enclosed in the CD, my lord, and that is in page number 25, my lord, in the CD, where my lord can find that at the relevant time. I may be excused, I have just made a pencil underlining, my lord, that at the time of the search and seizure, videography was done from the side of the police. Now that may be in a different case, maybe different thing, my lord. Why the police
So
came?
Mr. Ganguly, it was on 25th November 2024.
At 3:0046 hours.
And come to the arrest memo.
Arrest memo.
Arrest memo is which day? 29. Arrest memo?
Arrest memo, page 37.
Arrest memo.
Arrest memo is time is 26.
On 26, time is there.
26.
Next date.
26th of November 2024.
At 2:50 hours. 02:50 hours.
So the time is.
So my question is, if on 25th 11/2024 3 a.m. I have been arrested by the police from my house, how can I be arrested once again on 26th?
But at this stage.
Now, Lordship, they are saying the videography has been done. Kindly consider, I don't want my bail, just consider my videography and the timing and their videography. Kindly seize their videography if any time and date is there or not. If I have been already arrested from my house, Lordship, even inside my house, the police is present. We have the video of that also with 65B and hash drop.
You are the only accused.
There are 4 accused named in complaint. 2 have been apprehended. Allegedly, I am one. And because my point is, Lordship, this is para 6 of my petition. Para 5 of my petition. I beg to excuse, Lordship.
Yes, we have seen that.
Another, Lordship, the ground why I was been arrested, para 6. My brother, who as per the FIR is absconding, was my pillion rider. Lordship, I am submitting documents. He is a contractor and supplier. The local political goons demanded huge cut money from him. On refusal, this has been done by the police.
The person, the pillion leader, their name came from the statement of the accused who have arrested. Their name came.
Lordship, I have two pen drive, one inside the house, another outside the house. The police arrived at my house at 1:55 hours and departed at 3
Any
2
other
hours.
person in custody?
No, Lordship.
One Saddam Hussein is there.
He is already in custody.
He is not connected with me. I have been framed in the case of Saddam Hussein.
How can we come to that conclusion, Mr.
Lordship,
Ganguly?
arrest.
It is our responsibility to go through the videography now.
Lordship, the photographs showing Khalis's photographs.
Then we are investigating the matter. Can we investigate, Mr. Ganguly?
By this way, the police will do whatever they want, Lordship. Frame every individual in a case of narcotics.
Okay, so we can see it. Yes, got it.
We are thinking to file writ petition against the police officers. That's another aspect. But till that, why an innocent person, Lordship?
Mr.
Photography from 205
We are
hours.
not getting it.
Lordship,
Third paragraph,
from bottom.
from the custody of Saddam Hussein.
No, then next line. Under proper seizure list,
Huh.
in presence of local witnesses, under proper videography from 02.05 hours to 02.55 hours.
Hmm.
Now in the previous page 10, second paragraph.
Does he have any antecedent, Mr.
No, Lordship.
Chakraborty? This person?
NDPS now, but he has other certificates.
I don't, no NDPS cases. Lordship, page 10, second paragraph. Local witnesses is next to impossible. Thus, home guards were made witnesses. So, whom to believe, Lordship? Second paragraph.
At 23-25, we look for
Lordship, at Mashaban near abandoned petrol pump, and then we placed our vehicle to intercept the flying vehicles. I looked for local witnesses, but the area is is isolated, and local witness is next to impossible. And on the next page, they say the search and seizure was conducted in presence of local witness and videography. This is sheer blatant lie, Lordship. An innocent has been framed by the police.
Now, where is the seizure list? Who were the witnesses?
Lordship, seizure list.
Page 9, my lord.
Lordship, page 14 of my petition. Two home guards are there. Two home guards are there.
This petitioner seizure list in page number 9.
Page 14 of my petition, I have filed it.
That is equal to 14, no?
14, yes. Home guard.
Two home guards.
Two home guards. Then they say, in presence of local independent witness, a videography search and seizure was done in their complaint. Now, since when this home guard become?
As there was no local witness, these two persons were included.
As per the page 10. But,
Page 10.
but page 11 says,
In presence of local witness.
local witnesses. Why are the local witnesses? Videography and search and seizure was done. So this is a clear case of framing the person, Lordship.
Yes, Mr. Chakraborty.
My lord,
How do
And I
you
have-
explain this contradiction then?
What should be watching it? What should be? Kindly see page 15, Lordship.
my lord. My lord, they may be,
Maybe.
they are the police personnel, but they are the local resident. One is
No.
independent witness, one is local witness. They may not be the independent witness, that is separate thing. But they are from same area, my lord, Dinhata. Where the place of occurrence, my lord, they are from that area.
Dinhata?
Sorry.
Dinhata is a subdivision.
There is a conscious, when incorporating them, you must have thought about this fact. Now,
We have
this
not written
couple,
independent witness, we have written local witness. Now,
No,
local
you
witness,
said
whether
that-
a police personnel can be a witness or not, that is a subject matter.
no, with this contradiction remains, no, that
No,
there
that's
were,
local
there were no local witnesses. There were no local witnesses that as such, we ask the home guard to be the witness. That is paragraph 2 of page 10. But in page 11, last you say, under property in presence of local, then it becomes a matter of course. So that is a matter of course.
That is a copy and paste, my lord, nothing else.
Copy and paste. This is going on, Lordship. He is admitting it in court. Kindly see page 15 of my petition, Lordship. Kindly see page 15. Lordship, kindly see page 15, Lordship. Page 15 of my petition, kindly see. SP was intimated on the very next day regarding all these things.
And what is this page 19 you have annexed?
Lordship, page 19.
The certificate
19 is the of the DVR, and the hash drop is on page 20 to prove the genuinity, Lordship. This is the original copy.
This minor mistakes, my lord, these are to, the entire case has to be considered, my lord. Only in one place is because local witness is not available or available.
This
my
is creating prejudice to the person, Mr. Chakraborty. Is it not prejudicial? In the backdrop of the situation, the mother said that you have done this. He writes to your SP. SP sits tight over the same thing. She complains.
Page 15. Page 15. The receipt copy is on the left top, Lordship.
Now, what had been the fate of this application?
Nothing, Lordship, nothing. Nothing.
Ashok, Mr. Ganguly.
In that case, my lord, let this be clarified, my lord. It has to be properly, my lord, because these things, what happened, my lord, they will be.
We
filing a
gave
writ
you
of-
the time
So
yesterday.
they have stated that they have also.
No, they
So let
cannot
the
be.
SP come tomorrow, my lord, and explain the matter before, my lord.
What explanation he will
But
give?
what happened, my lord? Why this? They have filed a videography. They are saying that they will be going for the writ. This order, the observation of the order will also have an effect of the writ application, my lord.
No, we will make it
My
clear.
lord, in that case, my lord, let the SP come tomorrow, my lord, at 10:30, my lord.
No, why? For what
Why? Because,
reason?
my lord, this type of thing, my lord.
If your investigating officer proceeds in this fashion, then you are saying that it is a matter of course. NDPS Act, matter of course. A stringent act, a person once taken, he cannot be left at bay. Now it is our discretion which you are applying. We may be wrong. You test our order. We do not exercise discretion in all circles. There are two things. We were minded to dismiss the petition, but the thing is there are two contradictions. First is as regards the arrest. Second is as regards the time and date of arrest and the witnesses. Durgavasu's judgment is there, Mr. Chakraborty, that this infraction cannot be taken easily.
Videography already we have given, my lord. Videography cannot be ruled out, my lord, at this stage, my lord. We have the copy, we have videography.
No,
of
we
the-
are not ruling out. We are questioning the consideration of bail prayer. Mr. Ganguly, learned advocate appearing for the petitioner submits that the petition
The petitioner, my lord.
Yes.
Lordship, I'm on behalf of the state lordship. Lordship, till now we did not get CD lordship. Lordship, I'm praying for 1 day accommodation.
My lord, the state is saying that she is not having CD, my lord.
Next circuit, yes.
No,
next-
kindly accommodate tomorrow, my lord. So he is in custody since 565 days, my lord. And there is no PO at Kalimpong, my lord, since December, my lord.
Lordship, I'm praying
Just
for 1
1 day
day
accommodation.
1 day accommodation, Lordship.
Not today, yes, next.
Grateful, my lord.
Next circuit, yes.
For the state, your lordships.
Lord, in this case, I am for the petitioner. On the last occasion, their bail was rejected of the co-accused. This is no dispute. I am on different footing altogether. In this case, I am charged with the provisions of NDPS Act, including Section 27A, punishment for harboring the offences. There were 2 vehicles. One was a pickup vehicle, light commercial vehicle, and other was Bolero taxi. I was the driver of Bolero taxi, and 2 of the co-accused hired me. They just asked me to drop them off from Kuch Bihar to Siliguri. And the narcotics was
Lordship, both are,
Mr. Sarkar, please do not interrupt. Let him complete. Thereafter, you make whatever submission you want.
151 kg of gaja was recovered from the Bolero pickup, not from my position.
You were driving which vehicle?
I was driving taxi.
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 You are the owner.
I am the driver.
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 So you went along with
Owner along with driver. Owner come driver.
owner come driver. So 2 persons wanted lift, you granted them lift, and you traveled along with the Bolero.
Bolero.
Achha, then Bolero and your car was intercepted.
Intercepted.
And it was recovered from your car.
Not from my car, from the pickup van. From the secret chamber of pickup van.
Very good.
Nothing was recovered from me. So in this case, I have a recent judgment of Supreme Court, only 2-page judgment. The let's start with head note. A taxi driver cannot be convicted under the NDPS Act without
So
direct.
are we convicting you, sir?
No, in this case, the driver was accused.
To show us it was the bail application.
It was not a bail application. This went up to
So-
Supreme Court and driver was acquitted.
So you
And-
will also be acquitted, sir.
Milords, in this case, it was recovered from the possession of the driver. In my case, it was not recovered from my possession. It was recovered from the possession of Rapijul Mia, other vehicle. So how it can be held that it was
From your vehicle, any contraband was seized?
no, Milords.
Yes, Mr.
Yes,
Sarkar.
Lorships, kindly see the seizure list, Lorships.
Yeah.
And these present petitioners and the yesterday Mousham Sarkar. He is the,
Mousham Sarkar.
yes, both are traveling by 2 vehicles and both are intercepted by the
Here
police.
it is Uttam Narayan.
Yeah,
Uttam
Uttam Nagar, from the Uttam Nagar also.
So Uttam and Mousham were in
All
taxi.
are. And Lordship, it will be clear from the page number 116, Lordships. The conversations and both the vehicles detained by the
Page 160.
160 conversations, Lordship. See here. Lordship, this one.
Yes.
Orange color, the number of the Uttam Narayan. And this is organized crime. Both are
Uttam Narayan is conversation
with this Mousham.
Mousham. When was this conversation? Actual date 12/3/2019.
Yes, Lordship. And they are arrested, detained by the police personnel together. And they are the joint position. Contraband.
Conversation was 5 years ago.
No, they are the traveling in the same car, same route, same way, same place.
But driver is not supposed
They
to know the
cannot say
whereabouts.
that they don't know each other. Same status. And he is the owner of the vehicle, not a driver. Huge quantity, 156 kg of the ganja.
156.
Yes, Lordship. And he is the owner of the
150.
vehicle. So why he plying the vehicle and along had been arrested by the 4 accused persons? Both are
Other accused person are in custody
Lordships.
and charge sheet submitted.
No, it very initial stage, your Lordship.
And,
Case has been instituted 1311, Lordships.
1311.
Yes, case was instituted. Very recent case.
Mr. What's your name, sir?
Mr. Gupta. Shubham Gupta.
Mr. Gupta.
My lord, kindly allow me to make one submission. I was only the driver.
We have heard it, Mr. Gupta.
Nothing has been recovered from it.
Mr. Gupta and advocate appearing for the petitioner submits that the petitioner has been falsely instigated. There was
There was a 12 p.m. fixed matter.
Eh?
There was a 12 p.m. fixed matter, my lord.
We know item.
Item 40, my lord.
We know that, sir. Wait, you don't have to remind us. We are aware of our list. Yes.
Item number 16. 15 goes. Next second.
Yes, 16. Who is there?
Lordship, before he submits, Lordship, I want to complete something. Lordship, it's a case where the victim got pregnant. Lordship, we need the DNA samples for it. So supplementary charge sheet is pending for collecting the DNA samples. So we need to see whether the DNA samples of this accused and the victim matches, the victim's Lordship pregnancy matches or not. So I'm praying for next circuit. Today I called the IO, Lordship.
Next circuit, yes.
I am for the state.
Yes.
My lord, on the last occasion, my lord had adjourned this matter on the ground that one more schedule was fixed, my lord, for the trial, my lord. But the witness appeared, my lord. No, he was not examined again, my lord. My lord, this is the certified copy of the order. My lord, I have the certified copy of the order. My lord, another schedule has been fixed, my lord.
No, what is the matter? Tell us about.
My lord, the matter was regarding, my lord, the allegation was under POXO and my lord 376 2N and 306. My lord, the girl committed suicide, my lord. There was a love affair between the petitioner and the girl for about 3 years, my lord. And the petitioner was working in Kerala. Over an altercation over telephone, my lord, she subsequently committed suicide while the petitioner was in Kerala, my lord. My lord, the petitioner is in custody for 471 days, my lord. My lord, charge has been framed on 14/5/2024, my lord.
475 days.
71, my lord. 471 days. My lord, that's approximately.
Charge has been framed.
Yes, my lord, on 14th of May, 2024. My lord, that's appearing at page 30 of my application.
And how many witnesses?
My lord, 28 witnesses, my lord.
Out of whom nothing, no one
Nothing,
has-
my lord. The complainant has not appeared.
Now you are present, on the date of the alleged incident, you were in Kerala.
Yes, my lord.
She committed suicide.
Yes, my lord.
And there was a consensual relationship
Yes,
for
my lord.
3
Yes.
years.
Yes, my lord.
Yes, Mr.
Lordship, Lordship, actually it is admitted that there is a consensual relationship, because in the suicidal note, what I find that it has been clearly stated that the accused, who is Dharmodev Rai, that they had a relationship, and but somehow
We have one matter fixed. Where it's not there.
Yes, if it is Commissioner. I'm assisting him in the
Mr.
matter.
Biswas, kindly tell us one thing. This amount of 33 lakhs and odd, which was paid by to the person to the
WBASL.
this payment was, Mr. Chakraborty, we went through your CD.
Madam.
This payment of these 33 lakhs
Madam.
was on the basis of a payment estimate approved by the respondent number 3 himself. That is the additional DM.
My lord.
So far as this scheme was concerned.
He's part of this conspiration, my lord. And my lord.
If he is a part of that, the
Madam.
proceeding is a disciplinary.
Yes, my lord.
proceeding
Yes,
is-
everything is. My lord,
Our
my lord,
query,
madam.
query to you is.
My lord.
The question that he has misappropriated, he has taken the money or he has taken some advantage by some transfer.
My lord.
This is a very serious allegation. We understand.
My lord.
But from the records, we find that this was on the basis of
All, my lord,
on the basis.
difficulty is that, my lord.
Your ADM is also there. Your
My
ADM
lord.
signature is there.
My lord, yes, my lord. This is a total, my lord, conspiration and crime. My lord. It is a constructed.
Then
by-
why you have not issued appropriate notice to the other
My lord,
persons?
all these proceedings is going on, my lord. Difficulty is there, my lord. The crime branch is now taking the matter, my lord. And after lodging the complaint before our investigation agency, my lord, investigation agency taking care with the matters, my lord.
We understand.
And my lord, there is opportunity given by your lordship, my lord. They are failed. He failed, my lord. But custodial integration is very much necessary, my lord. My lord, on custodial part, my lord, there is some procedure, my lord. We are not cannot fulfill that procedure, my lord.
We are asking a question to
My
you.
lord, my lord.
We have not granted him the relief.
My lord, my lord, my lord, my lord.
Please assist us.
My lord.
The complaint was on 6th September 2023.
My lord.
24.
My lord.
Pursuant to High Court, sir.
My lord.
No,
You
4th
registered. The
4th of
complaint
December.
was prior 4th December.
My lord.
Yes, take the case then. Kindly come to Mr. Chakraborty. Kindly come to this. This page 77 of the application.
77 of the application. কোথায় রাখি এতক্ষণ ধরে
First come to page 58, Mr. Chakraborty. Application copy is not there with you?
Yes, madam.
Page 58.
Madam.
Acha, in reference to above, I am to inform you some of the joint visit was conducted in presence of executive officer, assistant executive officer at the proposed site on 26 January, where it has transpired the scheme was already executed by some other implementing agency.
Yes, madam.
And the spot decision was taken by the executive officer as per proposal of the assistant executive officer. That the scheme will be executed at JDA Bastard. So there is no mention about the petitioner here.
My lord.
You are saying that this document is a fraudulent document. Fake.
My lord, note sheet is there, my lord. I'm
Please, Mr. Chakraborty, please note our queries, then you will make yours.
My lord.
Page 58, petitioner's name is not there. Now kindly come to page 78.
Not 77.
70.
Sorry, 77.
77. Yes, madam.
This is the payment order.
Madam.
Acha, to whom the payment goes? On allotment of by the department under head of the following amount is released in favor of West Bengal Agricultural Industries
Agro.
another government institution.
Madam.
So this payment, it is not that the payment was made at his instance. It was through the usual procedure of government sanctioning loan for the purpose of disbursement.
my lord.
First. Now now the complaint which has been lodged against him initially, that was on 6th September, challenging which he went to High Court.
My lord.
Page
Before the-
60. Kindly see.
Before the DM. Before the DM Alipurduar.
No,
by
page 60 is the letter, 13 September 2024.
Lord, the complaint is the prior page, previous
Yes,
page,
Malak.
59.
So
Yes.
DM, what is saying? Kindly come to first, second, third, fourth paragraph. For evading his responsibility, petitioner has quoted the executive officer to spot decision
My lord.
on the side change, and then the AEO assistant kept the file with him, which is not corroborated by other proof and does not seem to be true. So ultimately he said that it is evident assistant engineer has kept got the payment done for a work which was not done at the original location. So issue a showcase notice.
My lord.
Challenging this, they went to High Court.
Hmm.
Disciplinary proceeding was initiated on the basis of the showcase notice after reply was given. That is pending.
My lord.
So as regards this transfer of fund, what is the involvement? We do not know. That is a matter of investigation.
My lord.
Now, your custodial interrogation which you are wanting is that the CPU and the other documents are not there.
Yes, my lord.
Now,
Yes.
why do
He
you
is-
want
he is
custodial
on
interrogation?
his custody, my lord. And the my lord.
How do you say from his custody?
Previously, my lord, 161 statement of the staff of the office, my lord, he stated that
Now,
usual course, the main key of his office, he himself holding.
That we will ask. Yes, you tell us. You were
And
under,
never key has been handed over, my lord. Never keys had been handed over.
you went on leave on 23rd on, you went on leave.
On 27th.
Yeah, just a moment. 27 September 2024.
Surprisingly, my lord.
When you went on leave, the documents were there
In my office,
in your office.
as per my knowledge.
Very good.
Yes, my lord.
When you came back, there was lock and.
Yes, my lord.
When you rejoined.
Yes, my lord.
Now the lock and key was not being opened. You went to High Court.
Yes, my lord.
High Court conducted an inventory, break open the lock.
Yes, my lord.
So now after breaking open the lock and key, the documents and the CPU was not.
Nothing was found in my. All
So
these-
when you went to leave Mr. Ghosh,
Yes.
why didn't you explain the charge to your officer?
I'm sorry, my lord, I did not follow you.
Suppose I will go on leave tomorrow.
Yes.
So I will tell my relieving officer, sir, in my courtroom, I have a tray of pens. I will hand over the charge of, I will hand over the records which are lying there to my next officer. Or I write a letter that these are the documents which are there. I am not coming from tomorrow. Take care of that.
No, my lord, that is not the usual procedure because my office being of an assistant engineer, it will have hundreds of documents. And my lord, this computer and
Right.
CPU.
Right. You know that
is-
was in September 24 when the proceedings have already started.
Yes, my lord.
So you will not be careful that I will.
I should have been cognizant, but how can that be held against me, my lord?
Oh, certainly
my
you were
exact-
in custody of those documents.
I
Mr.
should have been cognizant about this, given the, my lord, prior. My lord, it was in my office, which was
My
put
lord,
under lock and.
kindly-
Mr. Chapu, he is already in trouble.
My
don't
lord,
trouble.
It was in my office.
This
from-
point you cannot explain, Mr. Ghosh.
I am explaining. I'll try my best to explain your lordship. I was in my office on 27th. I went on leave. Yes, it is a fact that prior to that, a disciplinary proceeding was initiated against me. Now, my lord, the fact of the matter is, we know nothing remains hidden after RG Kaur's incident. That if you don't belong to a political tribe, if you are not their friend, then you are their enemy. That is simply what is happening here. Behind my back, my office is put
Mr.
under lock and
Ghosh,
key. Yes,
Mr. Ghosh, I have a CPU in my office.
yes, my lord.
I am conducting a court.
Yes, my lord.
Tomorrow, when I will be finishing circuit and going off,
Yes, my lord.
everybody knows here that these are the things in my office.
Yes,
Now,
but-
the next member who comes, if he comes and finds that something is not there,
yes, my lord.
he will tell the superior that why it is not there.
Yes, my lord.
You are a government servant,
But
you are
the
an
question-
assistant engineer.
But the question, in such a scenario, my lord, would your lordship be informing them in writing that these are the inventory of these items?
Certainly. I am apprehensive because this is the coterie, this is the collusion there under the, I will be hauled up. I will not, natural human feeling is I will do.
It is certainly so, which is why, my lord,
Which you have not done.
which is why, my lord, my custodial interrogation should not be necessary.
Exactly, that is the point.
My lord,
We were in
a
your
list
favor
of
after
20
that juncture. But when the question came of misplacing of documents, it
Yes.
can never be found unless you are interrogated. It can never be
Yes,
found.
I can be interrogated, subject to this court's, my lord,
Anticipatory
subject to
bail,
this
this
court's, my lord,
relaxes the regards of
superintendence.
arrest.
No, my lord. I will appear before them every week, subject to your lordship discretion. I will be there for the entire day, my lord. I will be there for 3 days a week. But my liberty should not be hampered, my lord. My liberty should not be hampered, my lord. My liberty is on a plate before your lordships, my lord. Kindly protects that. That is my humble prayer. I will cooperate with them 3 days a week, my lord. I will visit the police station. I will visit the police station, my lord, thrice a week, if your lordship so direct, till the investigation is completed. Any stringent condition, my lord.
Yes, I prefer.
Kindly, my lord, considers the conspiracy which is happening
But
behind
you
my
We
lord.
are considering for 3 days, as it is a sensitive issue,
My lord.
we want to give appropriate audience to you.
Yes, my lord. Yes,
Arrest is a very difficult thing.
my lord.
It humiliates, it puts scars upon mind.
Yes, my lord.
We know that. That is
Yes.
why we have heard you extensively. We have considered the case diary.
Yes, my lord.
We failed to get an answer. We are interacting with you. We have
Yes.
not passed our order.
Yes.
We fail to understand that when a person like you, when you know that there is a conspiracy behind you, why will you not write a simple letter that I am leaving the office, sir, take control of these documents?
My lord, right after
Show us one letter, we grant you bail.
right after rejoining, I informed that.
After rejoining, you have done.
Lord, that was a fallacy.
Therefore-
That may be a fallacy on my part.
How?
But
That-
can it be held against me, my lord?
That opens the door.
In
That-
this kind
that
of a
opens
criminal
the door.
investigation, where there is nothing against me. In this kind of a criminal investigation, where
Everything against
three casual staffs are, my lord, examined,
everything against
and my lord, they are trying to hold this charge against me. I'm telling your lordships, my lord, I will visit the police station 5 days a week. If necessary, my lord, 7 days a week. But my lord, my custodial interrogation is not necessary, my lord. That is my humble prayer. I will visit the police station every day of the week. Every day of the week, my lord. I will be there for 5 hours a day. But after that, I should return back home, my lord. That is my humble prayer.
Ashok, Mr. Ghosh, learned advocate appearing for the petitioner submits that the purported complaint had been lodged. That the complaint had been lodged against the petitioner our best to, because some matters will not be done, I think, in this present.
We'll wait, my lord.
We have been checked already by the advocates. So appropriate matters will not be here.
Good.
Please, you come here by 4 o'clock. Let us see what.
I'm here, my lord, I'm here. Good, my lord. I'm extremely sorry, my lord, for
Let a pen down. We have discussed the arguments advanced by both the parties. We have considered the judgments which have been placed, upon which reliance was placed. We have held that the tribunal, upon dealing with the factual issues, arrived at specific findings, and we do not find any error. Least to say any patent error of law in the order impugned, warranting interference, writ petition dismissed.
Grateful,
Grateful, my lord.
Yes, next, item 20.
Item number 22, but I for the petition.
You're there? Yes, what is the matter?
But offense under section 498A 304B 34 of the Indian Penal Code. But petitioner was arrested on 17th of February 2024. At present, 368 days in custody, my lord. But charge sheet, my petitioner is the husband, my lord. Charge sheet was submitted on 8th of May 2024, my lord. And total 21 persons was charge sheeted, cited as charge sheeted witness, my lord. This application earlier, but charge sheet has submitted against 3 accused persons, my lord. Out of 3, 2 are on bail by this Honorable High Court. On 14th of November 2024, the father-in-law and mother-in-law granted bail. Kindly see page number 12 and 14. My application was rejected and father-in-law and mother-in-law granted bail. And kindly see page 14, 12 to 14.
They are 60 and 64 years.
Yes, yes. But kindly see page 14, paragraph 8. But my application, kindly see page 14, paragraph 8. My application was rejected at this stage, my lord. And my lord, after this rejection, 3 months has been passed, my lord. There is no progress in the trial. Even, my lord, the copy
You
was
are in
not
custody for how many days?
368 days, more than a year, my lord.
And charge sheet submitted.
Charge sheet submitted 8th of May 2024. After filing of charge sheet, 9 months has been elapsed, but till date, copy not served. Even case was not committed before the Court of Sessions, my lord.
Yes, Mr.
And my lord,
Lordship, Lordship, the victim committed suicide within the 8 months of the marriage. The postmortem report clearly stated that it's a case of suicide, no doubt. But at that time, a 10 weeks male fetus was also there. She was pregnant.
and my lord, No, no, even
Copy is not served, charge not
case
framed.
was not committed yet. But because de facto charge 8th of May, man.
8th May 2024, 9 months before.
9 months before, man. Kindly consider, man, at any stringent condition, man. Because, man, the de facto comment also filed an RG petition, man, for further investigation. It was allowed, and, man, no, for further investigation, man. It was allowed, man. And till date, man, the waiting for the report, man. There is no chance for early commencement of trial, man. Kindly consider.
That is awaiting report. Then
But
try
for-
your luck before the next bench.
Man, the order has been passed long back, man.
Very good. When was
Till
the-
that,
further investigation was directed by the court?
yes, man.
So that was when it was the order.
Malat, that was Malat.
Show us that order.
Yes, Malat. I'll show you.
Further investigation proceedings, CS not submitted. Next hearing date 24/12.
30th September.
Actually, that date has been passed, 24/12/2024.
Show us what is the allegation, show us complaint allegation.
No 164 statement has been recorded, but the statement of the mother of the victim, page 39. CD has already been.
But as per the FIR, the allegation are.
We have heard you.
But my one line, man. As per the FIR, Marat, allegation against the all charge sheeted accused person are same, Marat. There is no specific allegation against any person.
Any specific over that against him?
Allegations are same.
2% granted bail, Marat.
The written complaint page?
But page 1.
Page 1 and 2.
No.
Of the case
you have
diary.
annexed here.
Yes, 45, page 45. 44 is the Marat formal part, written part is 45. 45, 45. The Asami gone, Marat. There is no specific allegation against anyone. It is last matter.
The Bhumik landed.
But Guho,
Sorry, Mr. Google landed advocate again for the petition. before the next bench. 2 PM fixed, 2 PM fixed, next bench. You are happy, na?
No, Lordship, just see, I back up. Just see the judgment, Lordship. I was very eager to move the.
Yes. Yes, yes, I know, I know. Oh, that, oh, we see it, doubt, it's a phone matter. Please, hardly learned advocates appearing for the respective parties. Stop, please, the matter for further consideration before the next available circuit bench. Yes. Oh, the case diary. The case diary is returned to Mr. Sarkar. Has been returned to Mr. Sarkar in court today. Yes, next. No, sorry. Yes, next. Yes. 23. Yes, what is 23?
Lordship, this matter was earlier heard and kindly consider the last order where the DNA report was done.
Yes, Mr. Chakraborty, you got it?
Sure.
We have sent it, my lord.
Sent it 5 months ago.
Then next circuit.
My lord.
Yes, yes. Package of 24.
Lordship, in the meantime, interim. Because the trial will proceed. The Supreme Court recently said, send back the matter for fresh consideration as because without DNA, the trial cannot be. Recently in 2025.
So you will get it on 3rd March. No? You mentioned before the next bench. It will be.
Interim protection, Lordship. Lordship, sui judice.
Yes, next. 24, yes. 24,
Lordship,
yes.
I represent the de facto, my lord.
Yes. Who is your other side? This online we will not do. You
No,
tell
my lord, please hear the matter.
Next side. Yes, next.
I'm for the petition. My lord, on last occasion, your lordship was pleased to call for a status report from the PP, and I have also collected the order sheets.
Where Mr. Chakraborty is there?
No, my lord, Subhashis Mishra.
Where is Mr. Mishra?
Give me short password, I will call.
Password. Yes, next.
26, Lordship, I am for the report was called for from the police concern as because why the trial is not taking place.
This is the report.
That is the report. Yes, sir.
My lord, the entire proceedings will have starting from investigation till submission of charge sheet, and thereafter what transpired in the learned trial court, everything is there in the report, my lord.
You
Date
are
wise.
study from 12th of August 23.
23.
Charge sheet on 11th August 23. Out of 4, 2 have been. And this is a case of 302.
302. And report was called for why
charges have not been framed.
No.
So, yes, Doctor. Yes, Mr. Chaudhary, what is the report?
My lord, report says, my lord, PO is on transfer for the last 3 occasions, my lord, matter adjourned due to non-availability of the presiding officer of the court, my lord.
That was, but prior to that?
Prior to that, my lord, PO leave, mostly, my lord, lordship will find on every date, PO leave is there. Jalpaiguri, my lord, 4th court, additional 4th court. My lord, delay is not attributed to the prosecution, my lord.
not to the accused even.
Yes, that is right.
More than 2 years.
My lord, the learned district judge may be directed to place it before some other additional district judge, my lord, who is available.
Now, when was the last examination of witness?
Not happened.
So, Lord, charge has
Charge is
been
yet to
framed.
be framed, my lord.
Charge has not been framed. No. Since
that is-
August 12, 2023, I am inside in the custody, Lordship.
That is due to, my lord, non-availability of the presiding judge.
But you will not. But you will not. I will not hamper my liberty if granted, Lordship, toward enjoying bail.
They are not
You
the
are
principal.
enjoying bail.
They are not the principal accused.
No, no,
He is the principal accused, my lord. Materials are against him. So, my lord, on lordship.
Is there any possibility of influencing the witnesses? How many
Definitely, my
witnesses
lord.
are there?
Lordship, in charge sheet, Lordship, 15 witnesses
15,
are there.
15, my lord, yes.
Lordship gives me any stringent condition, Lordship. Any stringent condition.
Page 98. My lord, may see the 164 statement.
Page 17, Lordship, I have filed the bail application of accused.
Page number 100.
Page 17 is Sessions Court order.
Sessions Court order. The only allegation against me is, Lordship, that CCTV. And on the other occasion also I pleaded, where my lord rightly pointed out that this is a matter of trial. That the gate video analysis has not been done. To compare that the person in the CCTV and myself is the same. Without the gate video, the
My lord,
CCTV
that
is
is
not
a
there.
matter of trial.
Yes, I have.
Because
already
they have
stated.
been identified in the CCTV footages, my lord. They were seen, my lord, dragging the dead body of the victim.
Not dead body.
With
A bag.
a sack
A
containing
sack.
the dead body.
Page
100, your lordship.
Page 100. 164 statement.
This is your first application.
Lordship, one second. No, Lordship. No, Lordship.
No. Previously rejected.
Previously, Lordship,
19th of August.
Yes.
19th of August 2024.
We already taken.
No, where is it?
I don't know. Oh. Gold ornaments of the victim were recovered from this petitioner.
No, from other two petitioners.
So this, Mr. Chaudhary, the 164 is a omnibus.
Allow me to explain, my lord. The other accused persons, they are the owner of the gold shop. My lord, this petitioner, after my lord, taking the bangle, the gold ornaments, my lord, he sold it to the co-accused persons. And my lord, thereafter it was recovered. My lord, the offending weapon has been recovered from his premises, from this petitioner's premises. He has been identified in the CCTV footage, my lord.
Page.
Caesar list is, my lord, page 72.
From premises, Lordship knows. Accessible to all.
Page 72, my lord, yes.
When is the next date fixed?
Lordship,
Next date-
13/3/2025 for production.
12 March. For
Uh,
production, appearance and
12
charge.
March, 12 March.
For framing of charges.
For framing of charge.
Production, appearance and framing of charge. Lordship, any stringent condition. Since August 2023, I'm in custody. More than 1.5 years.
Offense is heinous.
Lordship,
Mr. Ganguly.
Lordship, if I am convicted, I'll be
Okay.
hanged even.
You are bound to do. After you're convicted, nothing remains.
But till the trial, Lordship.
But no witnesses have been examined, nothing has been done.
Lordship, that is not due to my laches, Lordship.
Can that be the sole ground, Mr. Ganguly? Can that
Lordship,
be the sole
at
ground?
this juncture,
That bail is not an exception, it is the rule. That is what you will argue.
Not only that, Lordship.
Oh.
Lordship, if there is no possibility of tampering with
So I
the
have
evidence,
delivered contrary judgment against you in Partha Chattopadhyay's.
Lordship, if Lordship, that's different, Lordship.
Why different?
Lordship, there is a
Mr. Sarkar is saying, why different? He's so happy that we are saying.
my client and the person my lord has passed does not stand in the same footing, Lordship. Is more heavyweight. The big picture is there, Lordship. These two are priests, Lordship. These two persons are priests.
Brutal murder.
In Bengali, we say Doritro Brahman.
Brutal murder.
Establish করে আমাকে ফাঁসি দাও, কোনো অসুবিধা নেই।
Now after the charges are framed,
Yes.
Lordship, when the court will be there, when the charge will be there,
then
Lordship.
we will consider.
Court is vacated, transferred.
Mr. Ganguly learned advocate appearing for the petitioners submits that Yes, next.
Item number 27. But copy not served, not next, sir. P76.
Next, sir, please.
But I am for the petitioner.
After 28 lordship, just receive the case, then tomorrow lordship.
Okay, yes. Next, sir, please.
Mr. Mishra was. I don't know, 25.
29.
25 minutes.
Yeah, next, begin your.
29
Oh, next.
29 করবে না?
Want to do it?
29 কি হলো?
Who is your other side?
RT, my lord, his diary has yet not been received, my lord. My lord, 740 days custody, only one witness examined, that to hostile me.
Not today.
Gratefully, lord.
Yes, next.
Item number 31. But I am for the petitioner.
Yes. Yes, yes, tell us.
My lord, this is my renewal of my bail application, my lord. Only, my lord, initially case was started under section by 8503. This is equal to 498. Allegation of 302 earlier, my lord. But charge sheet submitted, my lord, 498, 340, my lord. My lord, I am the husband, my lord. She committed suicide by hanging, my lord. I am in custody about 214 days, my lord.
When did you last approach?
My lord, rejected, my lord, on 17 December 2024, my lord. There, my lord, till today charge not framed, my lord. After 5 years of marriage.
Charge framed.
No, my lord.
So what is the change after the decision?
No change.
Change is, my lord, on custody, my lord. There is no remote possibility of commencement of trial, my lord. After after 5 years of marriage, my lord. Kindly.
Initially, it was under 302.
Yes, my lord. Yes, my lord.
And now charge sheet has been filed.
490, my lord.
You have annexed the charge sheet.
Not annexed, my lord. Charge sheet submitted, my lord. On 498 to 304B, my lord. This is, my lord. 85, 82.
How many days marriage?
And after 5 years, my lord. This is the charge sheet, my lord. There is no external injury, nothing, my lord. No
Yes,
allegation.
Mr.
Kindly see the postmortem also, my lord.
My lord, there is a rejection, my lord, in the month of December. And my lord, after that, there is no change in circumstances. My lord, charge sheet has been
Even except the passage of time.
Yes.
Right.
That's it, my lord. And there are statements recorded, 164 statements of the father of the deceased.
No, but you have not framed the charges yet.
My lord, charges will be framed.
And there is an alteration of the sections. From 302, it was made 304B.
My lord, that is there. Next date is, my lord, 24th of this month. 24th, 20 তারিখ।
It was 85 and 103, later 82 added. 80 subsection 2.
Yes, my lord. 80 subsection, 304B. My lord.
And so 302 has been done.
103.
103 is still there.
No, my lord.
That is what this says.
My lord, can you see the, my lord, postmortem report? It was hanging, my lord. It was added. Thereafter, charge sheet submitted, my lord.
Who are you before us?
My lord, husband, my lord.
Manik Bormon.
Yes, my lord, husband.
My lord, next date is fixed.
200.
Next date is fixed on 24th of February, my lord, for next week, for framing of charge. So, my lord, at this stage, my lord,
In course of hearing, we have been
My lord.
informed that charges, date for framing of charges has been fixed on 24th of February
2025.
2025. Stopping you thereof, release the matter for further consideration before the next available circuit bench on 6th March, subject to the completion, subject to the convenience of the court. Yes,
I'm grateful to your lord.
at a password where
Lordship, item number 29.
don't mention this manner.
So, please tell.
Yes, কোনটা password হয়ে রয়েছে?
Ask over matter item number 25.
Petitioner থেকে you are for the petitioner.
Can't make his the petitioner is
Where is he?
coming.
Yes, you have got the report.
My lord, I have also the copies of the certified.
My lord, may I hand
copies.
over, my lord, the status report, my lord?
Man,
These are the order sheets, my lord.
when was it last rejected?
10 September 2024. After that, my lord, charge has been framed on 9 September 2024. And since then, the case is in stagnant condition.
How it can be framed? 10th of September it was rejected.
My lord,
Then 9th it was. How?
9th in the trial court charge has been framed
Huh.
on 10th September. Bail petition was rejected by the Honorable Coordinate Bench. Now, my lord, I have surrendered before the CGM Jalpaiguri, and since then we have in custody.
Lord, the next date has been fixed on 4th of March 2025 for examination of CSW 1.
My lord, kindly see the order sheets. There is no contribution from our end for that delay. Each and every day we have been produced from the jail custody. PO is on leave. Even on the last day, my lord, can you see the order sheet? Prosecution did not take any steps.
We have been informed. We have been informed by Mr. Misrol and the advocate appearing for the state that the next date. This report has finally be kept on record.
Lordship, item number 34, same case. Another accused person. Item
34 also, who is the petitioner?
I am the petitioner.
Same, ওনাদের নাম দিয়ে দিও।
দিয়ে দিচ্ছি।
You have got the report. Have you got the report?
No, my lord.
Did we ask for any report?
No.
Same report, same report. The report.
Get the report. আচ্ছা ঠিক আছে একসাথে।
My lord, with regard to item number 25, same report will be, my lord,
20,
considered.
25.
25.
35.
Item number 32.
Yes. Next circuit, next.
Item number 33.
My lord, service not yet completed.
Next circuit.
Item number 35.
35. I for the petition. 35, 34 হয়েছে, 35.
35 হয়ে গেছে।
35, who is there for your other side?
34.
Lordship, 35 is not, I am the petitioner, Lordship, 35.
CD not received, lordship.
35 is, I am the.
35 CD is not there. 35, who is for?
I am for state, lordship. CD not received.
35.
Next circuit. Yes.
Lordship, can we fix up tomorrow? Lordship,
35.
can you, tomorrow is
Try
possible.
your luck before the next circuit. Yes,
Sir,
next 30.
Item number 36.
My lord, I appear
I am
on
for the
behalf of the
state.
petition.
I am for the de facto complaint.
De facto complaint বাবার হয়ে? De facto তো dead.
De facto
Wife
কি
of-
করে dead?
Wife of the de facto complaint.
Wife of the de facto complaint. Yes, my lord. Yes, my lord, may I? Yeah, my lord.
Yes.
Yes, my lord. May it please my lord, I am in charge under 498A, 494, 304B, 302, 315, 120B, and 34 of the Indian Penal Code, my
You're
lord.
the husband.
Yes, I am the husband. My lord may come to the FIR part, my lord.
How much delay custody since?
Custody since, my lord. Custody is 256 days, my lord.
This is the first application.
No, my lord, this is the second application, my lord.
When was it last rejected?
It was last rejected
5th of December.
Yes, 5th of December. But my lord, the change in circumstances.
Give us a minute.
Yes, my lord.
Yes, what is the change, sir?
My lord, the change in circumstances would be, my lord, that the parents, after suffering incarceration, have been released from bail, my lord. No, my lord, allow me kindly, my lord. On one point, allow.
You're allowing me?
Yes. Now, my lord, from the FIR, it seems that they have been informed about the incident. The victim herself informed, and they have directly approached the hospital. From the written information, what they have lost. But from the 161, it appears that, my lord, they both the parents of the victim and the in-laws of the victim both were there. Secondly, my lord, the petitioner was not present at the house. He used to reside in Siliguri. Third point is that, my lord, that
On
he has
the date of the alleged incident?
No, he was not there.
So she committed suicide?
Perhaps, my lord. And the third point is, my lord, that 250
Then
days
what is the allegation against you? 5 years, within 5 years, she was pregnant and she has expired.
Yes.
What is the complaint against you? What is the overt act upon you?
Nothing. All are omnibus allegations, my lord. The thing what she complained to her parents, the last thing is that she is suffering a bodily pain.
Yes, death was due to poisoning.
Yes.
Yes, tell us.
Yes, my lord. My point is, my lord, that I have suffered 256 days detention. Now, my lord, there is
submitted.
Yes, my lord.
5th of December.
Yes, my lord.
No.
So,
when was the charge sheet submitted?
19th of August 2024.
So, my lord, thereby my detention goes rule because there is no purpose of detaining me because no statement is to be taken out from me. Neither I have the.
Now, my lord, his prima facie role, Lord, is forthcoming from the materials collected during investigation. And moreover, Lord, there are 3 accused persons who are absconding. And due to their abscondence, Lord, we are unable to proceed with the trial. That is the difficulty, Lord. Our officers
Who are absconding?
Lord, his elder brother, his
And wife
and his wife.
Different place. They said the different.
I am for the de facto complaint.
What is he was not there on the date of the alleged?
Yes, sir. He was very much there. He was very much there.
He solemnized the second marriage during the subsistence of his first marriage.
Because
and Milord, since he has solemnized the marriage, Milord, so it was very much necessary for him to eliminate his first wife. And that is the reason, Milord, it is case under 302. Milord, statements have been recorded. The lady was 7 months pregnant.
My lord, I am a Muslim by religion. I have every right to make a second marriage.
Lord, page number 81 is the 164 page.
So,
Lordship, I am for the de facto complaint, Lordship. Within
page 81.
Charge is submitted under section 302 or?
Yes, charge sheet are 302.
Where is the postmortem?
Page 99.
By administering poison.
My lord, she was also subjected to injection for her pregnancy on that day, and she was asked to rest for a while, but she did not. So we actually do not know what reaction, because FSL report is yet to become. And my lord, my point is on a different footing, my lord.
Lordship, may I? Lordship, may I?
My lord, may I?
Lordship, one indulgence, Lordship.
The dictionary is languishing lasting for 256 days. Yes, 36.
37.
Yes, next circuit. Next. 39. 39. Next circuit.
39 for the petition.
Who is for the petitioner?
The next circuit.
Yes. 39. Yes, what is your case? What do you want?
The anticipated field cultivated about the Raja plant has been recovered.
Not this week, next circuit, yes. Who is for the petitioner? 40, who is for the petitioner?
My lord, this case of juvenile matter is referred to the
Next
larger
circuit,
bench.
yes, 41.
41 I am for the petition.
Yes. What is the matter about?
Matter is that a small quantity of lithium plant has been recovered from one Ubir Sheikh. From he has been granted bail by the learned court below. From his custodial interrogation, my name has been written. Neither my land, nothing has been recovered from my possession. It's a small quantity, 1 kilo.
No.
Specifically stated in the manual.
1 kilo, that is the sample which has been taken, one tree. It was cultivated in a 10 bighas of land. So my lord can understand how many plants can be cultivated in a 10 bighas of land. Only one was taken as a sample, my lord.
Okay, and over my lord, the learned court billow's order, where my lord, the principal accused has been granted bail.
Okay.
1 kilo has been specifically stated in the FIR. So far, my lord, the notification is concerned, my lord, 50 kilo is my lord the commercial quantity.
50 kilos. So Mr. 1 kilo. Exactly, Babu.
Interim bell, is it an interim bell? Interim bell.
আরে কে কারবেন কি না? This is my
আবার শুনেছি hardly give us some time. Fourth line from second line. After his demise was taken over by Kavi. I'm used to that. Who has been granted bail?
Kobir Sheikh.
Kobir has been granted bail.
Or bail, interim bail on, interim bail on the ground of his son, illness of his son.
Interim bail. But he is the cultivator of that land, he is the Malot, the Rayat of that land.
Oh, and bail was given because he was
His
son was
Interim bail.
ওইটা আর বলতে হবে।
But I have
It was not with you.
no land.
my lord, if we calculate, my lord, the land is 10 bighas.
Just one.
That will be good. বলতে হবে।
no calculation is required as per decision of the apex court is cultivation of poppy.
Poppy, my lord.
That is the only ground.
My lord. So we can estimate that
Where you are
36
getting 10 bighas?
from the FIR,
To us, where? 10 bighas of land.
10 bighas.
আচ্ছা বোধহয় এই মুহূর্তে দেখছি না।
1 kg. 1 kg at the time of collection of sample. Where do you find Mr.
My lord, this is the FIR fourth paragraph of this.
No, we have you can fourth paragraph is during course of investigation.
During course of no, this is at about 12-15 hours, madam.
Forwarding letter.
Oh,
Forwarding letter.
show us the
3.29 acres, that means 10 bighas.
that you are along the. What you statement to land cultivate for him. He is not the cultivator, Mr. Chakraborty.
But
His person's name has transpired on the basis of whose statement?
statement at page number 20.
20.
20.
Oh, COVID.
দুইজন মিলে মুখোমুখি অবৈধ হয়ে কপি ডিস করে সাহায্য করার সাথে মালিক নয় বিভিন্ন কোনো
Charge sheet submitted. Not submitted, anticipated even. Surrender. Our key model. You were cultivating the land.
No, my lord, I am cultivating. Neither I was the Rayat, but not over my
There is a, actually we have the call details also.
CTR, my lord. CTR, I know value, my lord. Secondary evidence.
It is said by the learned advocate on behalf of the petitioner that that he is absolutely innocent and has been entangled with the offense as per statement of the principal accused. Stop. It is this petitioner is no way connected with the offense alleged. So he prays that this accused petitioner may be enlarged on bail. Learned advocate for the state raises objection by submitting that there are It is submitted by the submitted by the learned advocate on behalf of the petitioner. It is further submitted by the learned advocate on the behalf of the petitioner that the principal accused has already granted interim bail by the trial court. Stop. Next paragraph. It is inexplicable. It appears from the order dated 14/2/2025 that these accused petitioner were granted interim bail on the ground of illness of his son. Stop. And it said cultivation was made on the land which area of the land which is about 10 acres.
Yes, next.
Next.
Not I for the petition.
Well, this is a case under section 14A and 14C of the Foreigners Act. Well, acting on a source information, police apprehended two persons. One is
Why your case diary is not good? Want it tomorrow or after it?
No, tomorrow. But I for the petitioner. Not praying for 1 day accommodation copy has yet to be served by.
Then come after next Saturday.
My lord, last chance if my lord, by tomorrow it will serve. I want to do the matter.
Not today.
I don't know what you got.
But I for the petition.
Who is your other side?
I do not know why. But to the clear.
Not today.
Not.
I don't know 45. But I'm 45. 293 is the 304 my lord. Petition number 1 is the mother-in-law. Petition number 2 is the father-in-law. Charge submitted. Husband was granted bail by the learned trial court. Mother.
Your father-in-law and
Father-in-law. Petition number 1. Petition number 2 is the father.
this is 304A. Is
198 and 304.
so your husband granted bail. It is your first application. Oh, anticipated.
Father-in-law, mother.
What is the name of your son? Incident happened within 3 months.
Yes. For years of life.
Statutory bail or 439 bail? Husband.
Husband.
What is the order?
There is no dispute. He is husband.
164 of the. Both Hindi and English, Hindi and Bengali, but that page on that page.
The complainant.
Yes, sir.
আমার জামাই কথা লিখা बेटी को मेरे दामाद ने फांसी लगा था दामाद की छेड़ दिया Do you have that order?
No, I don't have to.
Mr. Poddar, an advocate appearing for the petitioner, prays for and submits that the principal accused has already been granted bail and he prays for an adjournment to produce the same. In view thereof, you want it before tomorrow. In view thereof, please be matter for further consideration on Kalkit date. Mr. Duksam বলে দেবে ওই তারা তারপর Mr. Duksam enters appearance on behalf of Mr.
Number 46, for the petitioner, allegation under section 448, 342, 325.
Hey, go slow. Get your throat choked.
Allegation under section 448, 342, 325, 302, 37 of the Vihan Code. Petitioner requires to email personal person before your lordship. All other who have been person grant principal admin and other person already granted bail by the honorable court. And the charge sheet already been filed and charge no trial yet not been started. Total 24 witnesses. Charge sheet 24.
When was it last rejected? Oh, this is anticipated event.
First time.
Kalavati
and my lord, the other.
allowed. Kalavati has been allowed it from the report it appears. On 18th December 2024.
But initially, Miller, application proclamation was issued. Something that was challenged and that was set aside. So take the case number 24 of my petition.
My lord. But there are out of my lord, there are 8 petitioners, my lord, 8 accused, my lord. Out of 8, 6 have been granted bail. Got you. These 2 accused have been placed under similar footing. Their name has been transferred from the 164 statement. Kalavati and my lord, Reena Goala. What is the incident is that, my lord, the date of incident is, but I don't remember it, but these people, my lord, dragged the victim, my lord, out from his house because the victim was threatening this Mukesh Goala's sister, my lord. And Kalavati Goala and Reena Goala are the mother and the sister of this Mukesh, my lord. So they took out the victim from the house, tied the victim in the beetle nuts. After that, they started beating him with the
making lot. If I am nothing is taken
from the 164 statements.
All the members of main members of.
So it was any specific overtime attributed to him?
Specific overtime, Lordship, actually, all of them are named in the.
Plus 160.
Yes, my lord. This is the eyewitness statement, Lordship. It's written in Hindi, Lordship. If I could,
My brother is.
Small statement.
Charge sheet already been filed.
আরে শুনেছি তো বে হিন্দি
No purpose will be start to keeping that customer.
দেখুন যে শুধু হিন্দি করতে
Kumar.
Mukesh Agarwal, Ajit Sethi, Sundarji, Gaurav, Kalavati and Raja. सब ने भी पीपली के पेड़ में बंद कर मारा
चमका मुझे गायत्री किशन ने मारते मारते हमारी ये सामने जान से मार डाला।
Where is the postmortem?
Postmortem report.
170. 170.
Charge is submitted. Charge framed.
Charge of 90. 24. Charge sheet file 21/8/2024. Competition has been made between
Effects of injuries and promoting research and HR. Others were granted and regular basis.
Others were granted regularly.
Actually, regular.
So you surrender.
The female personnel
Wait, my female.
both are female millers, Kolaboti and both are female millers.
So at the time of thrashing out, you did not remember
In the
that I am a woman.
In the A5 miller, they are not. A5 miller.
So that is why we are saying you surrender. You get the will.
Kindly miller, kindly miller.
Achha, kindness for what, Taylor?
The female personnel.
We will be giving you another brief. Go and.
Kindly miller. The two female personnel, the charge sheet submitted miller. 24 witnesses are there, miller.
We are not on that. Why we will differentiate between you and the others when allegations are the same? Allegation is same. All have omnibus allegation. All made. So 6 of them went and got
Warrant was issued. Warrant was issued.
Warrant was issued. Initially, warrant issued, miller. Subsequently, proclamation also wrongly proclaimed. I have challenged the proclamation. That has been.
That was different thing. The procedural defect maybe. That's why the order was passed. But
It was passed. It was passed. Thereafter, the file is.
That is different. That is the warrant has been issued now.
What purpose will they serve, sir? Two female personnel.
No, no. Female, does it have any different status? Same.
Equality, my lord. Equality means the story like same is equal, but practically it is not that category mentioned. Your lordship knows, my lord.
My lord, one thing, my lord. My lord, one. Named in the
it is led by the learned
47, not today.
Grateful.
Item number 48. Next.
You're for the petition or?
State.
Who is for the petition? Oh, this you are not interested.
No.
No, next item.
Item number 49.
49 also will not no case there.
Next item.
Item number 50.
Yes, then I.
Lordship, kindly make it next circuit, Lordship. We did not receive the case file, Lordship.
Next item.
Item number 51.
51, I beg to appear for the petitioners. Lordship, this is a matter which arising out of Arms Act. The offences were registered under section 25(1)(a) and 35 of the Arms Act.
Lordship, kindly make it next circuit, Lordship.
Lordship, can you fix it tomorrow then?
Go to the next item.
Next circuit, Lordship.
Item number
Grateful, Lordship.
52, you are there. You are there.
The petitioner number 1 is the senior citizen widow.
Yeah, yeah. Yes.
Petitioner number 1 is the senior citizen widow, and the petitioner number 2 is the mediated her only son. The effective complainant has launched the complaint on 19/12/2024 with the Siliguri Women's Police Station. And the police station, they have registered a case in number 141 under section 85, 89, 152, 362, 351 of BNS, along with section 4 of DP Act. Now, this date of 19/12/2024 is very vital, and I will apprise your lordships on that ground, slightly a later on. Actually, the effective complainant and the petitioners, number 2, they were batchmates in Siliguri Institute of Technology.
She is a lady.
No.
Complainant?
Complainant is the wife of the petitioner number.
She is the wife of petitioner number 2. Yes.
And petitioner number 1 is the mother-in-law of the complainant.
Yes.
Now, the complainant and the petitioner number 2 were the batchmates of BCA course in SIT since 2004. And from 2008, their friendship turned into a best friend and a relationship grew in between them. 2018, they got married with the consent of both the families.
So what happened for 10 years?
They were working in Calcutta, they resided in Calcutta. Now,
when 2018 was the marriage.
The best part, the thing is this, from the month of February 2019, this petitioner number 2 was attacked with vitiligo disease.
What is that?
Pigmentation of the skin, sheti, what we call in Bengali. So the petitioner was
What
under
is the medical name you said?
vitiligo.
VITI.
VITILIGO. So since then, the conjugal relationship in between the complainant and the petitioner started to drift. Actually, there are so many people who actually are allergic to see a
Next,
people.
what happened?
Next, what happened on thereafter.
Thereafter, the lady, the complainant, she filed a matrimonial divorce against the petitioner number 2, which is pending before the landed court actually.
That is of which year?
To 2024.
Yes.
On 19/10/2023, she filed the case. The match suit number is 467 of 2023.
Yes.
Now, interesting part is, thereafter, when the petitioner number 2 appeared before the court, talk of compromise, both are quite young, so let us not go for a long litigation period. Let us file a joint petition of divorce and compromise talks were going on. In pursuant to that, I draw your honor's lordship's kind attention to page 35, 36,
No, what happened?
38, where joint petitions were filed by both the litigants before the court, praying for time to file the
On when? On
yes,
when it was?
yes, yes.
When it was filed?
It was filed on joint petitions from 33 to 37. I
9th April 2024. Was received.
33, 9th April 2024.
Then what happened? Then what
18, then in between the advocates with the parents, long discussions were going on. I have annexed all those.
Then it failed.
All those draft papers.
Very good. Then what happened? Tell
From
us.
pages 39 onwards till last. Along with all the WhatsApp messages exchanged in between the advocates of the petitioner number 2 and the complainant. But as there is a joint building was purchased in the name of the petitioner number 2 and the complainant jointly at Calcutta, so that has to be settled. Now there was a proposal from the girl side
Mr. Chakravarti, please.
That the boy, that is the petitioner number 2, should make a gift. So there was a condition, okay, I'm ready to relinquish that house, provided you obtain a no objection certificate from the bank that I have no loan against that. Because the loan was sanctioned in the joint name of both the petitioners, the petitioner number 2 and the complainant, and they were making their 50% part of the EMI to the bank. Now the compromise paid on 18/12/2024. Just see, on 18/12/2024, the compromise failed and a petition was filed before the court by the petitioner number 2 that we are going to contest this suit. This FIR was lodged on 19/12/2024. Now, if we come to the contents of the divorce application.
Where is the complaint? Where is the complaint? You have annexed it.
I have annexed the wave copy. It is not that visible from page 9.
Just give us 2 minutes. Now she has given birth.
Yes. So she filed this application on FIR on 19th. Now, if we look at the contents of the divorce petition filed by her and the complaint, it is a replica of the divorce petition. Only few lines have been added to attract the sections. Like I draw your lordship's kind attention to the subject of the FIR laws. FIR against Sri Jeep Mojumdar for physical and mental harassment because of unlawful demand of dowry. Now, if we come to the mid portion of the complaint.
Yes.
My lord, I've already gone through the FIR statement. FIR, my lord, there are 161 of father, brother, and mother, lordship.
Of the lady.
Of the lady. So they have stated that this person has tortured and he has received such and such amount of money. And there is one requisition given
So
for
what is
necessary
the
information.
criminal angle of this case?
Criminal angle is 498.
Child is very young. Child is must be very.
No. There is no issue.
Pregnancy. She was pregnant.
She was pregnant in the year after marriage. She got pregnant, but as the petitioner number 2, he was attacked with that disease. So they decided to abort it actually, because this disease is a genetic one. So they feared that the child may have that disease. So what they have done, they have given an allegation that I sat on the abdomen of the lady, I sat on the chest of the lady and tried to get rid of that child. Man, this is
That was when?
This is 2019.
That is why the police, the IO gave a requisition for necessary information regarding page number 38, lordship. Kindly look at page number 38.
2019 incident.
We have hardly.
Page 38. To the doctor concerned, page 38, lordship, page 38. What was the cause of it? That is still pending.
When was the abortion, sir?
2019.
19?
Yes.
Petition number, it is
9 of NDPS Act, Lordship. Nothing has been recovered from my possession. My name has been
17B.
B. Lordship. My name has been transferred from the statement of the co-accused. Nothing has been recovered from this petitioner's possession, Lordship. The FIR is at page 9, Lordship.
It is lesser, below commercial
quantity.
And 29, harboring.
Yes, Lordship, abatement.
But actually, the allegation against this petitioner is that, there are 4 petitioners, no, 4 not 5. 5 petitioners.
Yes.
Allegation is that one Marina Bibi. And another one arrested in whose possession substances was recovered, madam. Near about 202 grams, and he was supposed to arrest that she was supposed to supply this to all this petition. Requisition for CDR has been sent, madam.
Below commercial.
That is the no.
It is said by the learned advocate on behalf of the petitioner that all the allegations as made against this petitioner are baseless, and they have been falsely implicated in this offense. So nothing has been recovered on the possession of this conscious possession of these accused petitioners, and the principal accused against whom the main allegation lies, against whom the main allegation lies, he is in the custody. So it is submitted that no purpose will be served.
Your Marina Bibi is in custody.
No,
he also cannot be. That is.
Lordship, she is in custody because the contraband article was seized from her possession.
But it was below commercial.
Yes, Lordship.
But 60 days is statutory period. How long? When he was arrested? No, he was arrested on 2nd of February.
Unless such no purpose will be served by putting the
60 days in the
behind the
statute.
bar for the sake of custodial interrogation. Learned advocate for
So
this.
before charge sheet filed, he cannot come.
Yes, that is the discretion of the special
And
court,
advocate
madam,
is
Planet Court.
What is your decision to arrest? Below
Madam?
commercial quantity.
No, we have to arrest, my lord. The quantity is 200 to
Learned advocate
250 is the
court
commercial quantity.
Also concedes the submission made as advanced by the learned advocate for the petition.
This has been circulated
It
in
is
largely,
also-
madam.
it
Now
is
they're
also submitted
always they're carrying
that
less than
the-
commercial quantity.
That,
They're trying to.
that the principal accused is in the custody. Stop. Peruse the materials on record, keeping in mind the involvement of this accused petitioner with the alleged offense, and also the and the since contraband articles which were contraband articles were below commercial quantity was recovered from the possession of the accused person who is in custody, and
Their names have.
their name have been transferred from the statements of the principal accused. So we are of the opinion that no purpose will be sought by putting.
Statutory restrictions are not.
Have said, for our opinion, the statutory restriction are not attractive. No purpose will be sought by putting this accused petitioner behind the bar for the sake of custodial interrogation. Allowed.
Grateful, Lordship.
10,000 to security.
Forgetful.
I have got the state in mind.
Allegation under section 85, 109, 115, 2 of the DNA. This was the 198, 307, 323 of the Indian Penal Code.
198, 307 and
323 IBC and section 3 for the dowry provision. Attempt to murder, allegation. Well, in the written, my petitioner between your lordship is the husband, my lord. We lost a complaint, mother-in-law lost a complaint on 5th October 2024 against the present de facto complainant and her family member on 5th of October. Before the particular police station. I have managed.
They are neighbors.
No, no, my lord. Dispute between the husband and wife. Mother-in-law lost complaint against wife of daughter-in-law.
Medical document.
Only allegation of abusive language and handling, no medical.
Within 6 years of marriage, the incident took place
Only allegation of
and
abusive language.
charge sheet not filed.
That allegation is your abusive language is it?
Yes, ma'am.
Say, and
Pardon. What is the allegation?
allegation he was
Mother-in-law lodged the complaint.
no.
No, no,
This is
ma'am.
another.
Mother-in-law lost
It's
complaint.
a counter case. He said
I lost first case, thereafter she lost this complaint. And her complaint, my lord, only allegation, husband came to her house and abusing language and heckling.
and the present complaint is that, my lord, within 6 years of marriage, physical and mental torture upon the
Only allegation physical.
wife, demanding more dowry. Charge sheet pending, my lord.
Is said by the learned advocate on behalf of the petitioner that all the allegations as made against this accused petitioner is baseless, form of false and concocted one. Stop. This accused petitioner.
Of the court granted and bail by your lordship, my lord.
Case diary is not available. Lordship. Next circuit.
Tomorrow, my lord. been granted by your lordship, making of registration, my lord. Tomorrow.
Now, what is the role of the this accused? Kujbihar district so far after Joy Bridge. Huh? অনুরোধ নেই তো সিটি চলে গেছে চলে গেছে না? ছাপানো দেখে না, না। One day accommodation. No city lordship. 57 or 7. I am for the state. Lordship, one indulgence, 58 and 60 are of same PS case. 58 and 60.
I'm happy for the petitioner. My lord, the petition, your lordships has already granted the anticipated bail in respect of the similarly circumstanced petitioner. My lord, lordship, although the case has been started under NDPS case, but the NDPS is not against the petitioner. The allegations more or less against them, they are scuffling with the police during the course of the raid. No, lordship, that is also not supported by any evidence. Your lordship granted, my lord, bail, my lord, in respect of the other who accused the petitioner before your lordship is the exactly similarly circumstanced lordship.
Yes, same footing. The allegation of NDPS, the provisions of NDPS are against one Hamidul Haq. Let me finish.
My lord, his name is also Hamidul Haq, but he is not that Hamidul Haq. He is the another one.
There are two Hamidul. The contraband was seized from the house of Hamidul Haq, who is the son of Ainul Haq, who is not before your lordship. This Hamidul Haq is son of
Lal Mahmud,
Lal Mahmud.
son of late Lal Mahmud.
Stands on the same footing. But my objection may kindly be noted. Ainul Haq. AINUL.
I'm grateful, your lordship.
My objection kindly be noted. Objection. Objection of the state may kindly be noted. Oh. 67.
Also same.
Lordship, Lordship, one indulgence in the order sheet of item number 60. Father's name is very important because the
No, father's name.
58. Chatterjee. আচ্ছা দিয়ে দে, দুটো দিয়ে দে 5860
Grateful, your lordship.
Item number 59.
I'm for the state, your lordship.
My lord, there was a proposal for arranged marriage. Accordingly, my lord, the petitioner and his family members went to the deceased victim house, my lord, to, my lord, fix up the, my lord, the marriage. My lord, after that, my lord, there was a interaction between the deceased victim and, my lord, the petitioner. They used to call, my lord, talk with each other. There was a, my lord, conversation over phone between them. My lord, a love affair gradually, my lord, cropped up between them. My lord, let me, my lord, complete, my lord. My lord, a love affair, my lord, matured between them. My lord, all on a sudden, my lord, the deceased victim family members, my lord, decided to, my lord, cancel that, my lord, arranged marriage proposal. Only on the ground that the petitioner's financial condition is not so good. My lord, out of that, my lord, the deceased victim committed suicide, and I have been implicated. My lord, I was the, my lord, the groom, my lord.
My lord, we promise.
Page 9, that is to, my lord, love affair and, my lord, indirectly been admitted on the file. There was a love affair. But the
Yes.
it's absolutely false, my lord. It has the exaggeration of, my lord, of the allegation. No. Seems when you were having this pleasure. But my lord, the Pune Dekha performance, my lord, that rituals happened, my lord, that the specific date I on 25th of September.
September
2019. My lord, from last 2 or 3 months. 2 or 3 months.
My lord, there was a love affair and the victim was the student of class 11 at the time of incident. And with a promise to marry, they loved each other, and after refusing, she
There
committed
was no denial on my part, my lord, to, my lord, solemnize the
and
marriage.
threat was made. Yes, my lord. No, my lord. Save and accept affair, there is no document. No, my lord. There is no reflection in the CD, my lord. Yes, my lord. Charge sheet is pending.
My lord, if
The
you will
case
also-
of case
Believe
of
me, my lord, I will surrender.
September
my lord,
2024.
my- Because my lord antecedent is clear, my lord. Nothing has happened so far has been alleged in the FIR, my lord. No obscenity.
This is the
nothing.
serial list.
No vulgar, my lord, picture.
So many WhatsApp chatting has been.
Any stringent condition, my lord, I will surrender my mobile phone. And whatever electronic gadgets
Next
I
page,
have.
my lord.
My lord, give me, my lord, that liberty, my lord, of clearance. My lord, I will surrender, my lord, the mobile phone, my lord. Is absolutely, my lord. My lord, I am happy. My lord, I will cooperate myself for any, my lord, any extent of investigation, whatever may be directed by your lordship, as well as desired by the, my lord, investigating officer. Because I have no obscenity, my lord. Nothing has happened to that extent.
This is the
It is a
WhatsApp
marriage
conversation.
proposal that has been cancelled from their part, my lord, due to my financial instability, my lord.
All are WhatsApp conversation between
That is
deceased
the,
and
my lord, the
the
usual
petition.
practice. Lord, sir, I beg of you. No. It's my cover.
Page 44. my lord.
Well, this is a case under section 442, 323, 325, 354, 506, and 34 of the Indian Penal Code, my lord. Well, dispute between the two neighbors, my lord. Co-accused has been granted bail, my lord. Page, my lord, 9 and 10, co-accused has been granted bail. my lord, the allegation is that on 20th of 2024, the husband of the informant sitting in his grocery shop. At that time, due to previous enmity, the petitioner along with his wife, that is the Nilima Bormon, went to the said grocery shop and my lord started abusing them. When my lord, the husband of the informant raised his objection, my lord, both the accused person have been assaulted him. My lord, that is the whole allegation. My lord, page 9 and 10, co-accused has been granted. My lord, I am Ravi Borma, wife of Ravi. My lord. My lord, kindly see the FIR at page 12.
This is the 164, my lord. Muscle bleeding absent, subsidiary and upper lip swelling, no other external injury found, no abrasion, no cut injury found. So this is the injury.
62, my lord. Lord, next circuit.
Lordship praying for not today.
Lordship, I am for the petition.
63. My lord, I am for the 63. Am I audible to that? No, maybe there is some technical noise.
Lordship.
Can you hear now?
Yeah, my lord, my lord. My lord, I am for the petition, item number 63. My lord, the petition is not
We
named
just
in
received
FI.
the CD. Kindly make it next circuit, Lordship.
What are the sections? 63?
My lord, I am not my lord, sections are 22B and 29 of the NDPS. I am not the person from whose custody any contraband has been recovered, my lord. My name has been transferred
What
from the statement
Mr.
of the
Sarkar,
co-accused.
what he's saying, no contraband recovered? What
Lordship, she did not receive, Lordship.
There was the CD. This is which item? You are in which item? 63.
Item 63, my lord. The petition
63,
is
the CD is not here.
Not Lordship.
Manjar Alam.
They are saying CD is not here.
Then kindly make it tomorrow, my lord, if possible. If
Tomorrow or after, next circuit. Choice is yours.
my lord, tomorrow.
This is for the
Grateful, my lord. Grateful.
tomorrow. Not
Deeply obliged.
Item number 64.
64, I am for the
Same, my
petition.
lord. Tomorrow kindly. CD not received, Lordship.
Case under?
See, cheating, Lordship. Well, I have 318. 420 actually.
Tomorrow, Lordship.
Lordship, just.
Tomorrow?
Lordship.
I'm the petitioner, Lordship. Out of 3 accused, 2 has been granted anticipatable from this honorable court, Lordship. Page.
You are same.
66.
You are equally situated.
Lordship, laser putting, Lordship.
Lordship, kindly make it not today, Lordship, 65.
No, Mr. Chokku, the CD doesn't come or what? They don't care about you.
No, no, my lord, actually, these were.
Your police officers do not give you any sort of
No, no,
weightage.
my lord, CPS.
Oh, that is what we see.
Actually, they
All CD not here, CD not here.
has come today, my lord, so we need 1 day time,
That was not submitted before us. We were said CD is not here.
my lord.
How does the investigating officer has such an audacity that the APP will call up and I will say CD and I will not bring?
My lord,
Such
with
audacity.
sequel, my lord.
Don't give indulgence to this.
My lord, definitely.
Petty police officers, they will sit above the head of the advocates. ফোনে বলে দিল অফিসারটাকে ফোন করে বলেছিলাম যে সাহেব লেগে আছে একজন লোক দুটোর সময় সে আমাকে কি বলছে জানেন আমার জুনিয়রকে বলছে আমি 10 দিন অর্ডার দিয়েছি 10 দিন অর্ডার নেই আর আমার জ্যাঠা সুন্দর করে প্র্যাকটিস করে ডাকিয়েছে এনেছি হচ্ছে হাতে ব্যথা হচ্ছে Yes, next one. Come tomorrow.
Item number 66.
But I'm for the.
Lordship, I'm for this step.
That's why I'm for the defense.
Right, offense under section 363, 323, 506, 34 of the Indian Penal Code and related to section 8 of the POCSO Act. Petitioner is aged about 19 years. And my lord, FIR has been lodged against my lord, total 5 accused persons. Out of 5, 4 accused persons granted anticipatory bail by the Honorable High Court. I have annexed the order, page 10. And my lord, kindly see the complaint, page 13, my lord. Page 13 of my application, my lord.
Yeah, just.
The petitioner had a love affair.
Yeah,
with
yeah, yeah. Who has got anticipated?
Other,
Amia, Bibi and others, that is mother and others have.
Yes.
You are the son.
I am the son. I am the,
Now what is your age?
but 19 years.
And
19 years
the,
old, that is,
and the daughter, the lady and the
16.
girl.
16 years old.
He was the 161.
Lordship 164, it is clearly written আমাকে মারধর করে
but
Lordship.
there is no allegation of rape, my lord.
164, Lordship.
Yeah, wait, let us.
And the allegation of assaulting is also the family member of the principal. Can you see the email?
Next please, sir.
There is no allegation of rape. There is a love affair between the. Wait.
বলেছে বিয়ে করার কথা বলেছে বিয়ে করা আছে কিন্তু আমরা এখন বিয়ে করতে চাই বাধ্য করেছে আমরা এখন বাড়ি যাবো
Any medical?
No, Lordship, the medical was refused. The medical was refused, Lordship.
Ashok.
It is submitted by the learned advocate on behalf of the petitioner that it is
Next circuit.
No, kindly make it not to them, lord. Kindly make it not to them.
Why then? Why you are not responding?
But they are not, I am waiting for their response, lord. And not to them, lord. Not to them, lord.
What are the allegations?
But yeah, copy has been service out of delivery, not has been served to victim, lord.
To now service complete.
No, not 12 minutes. I have seen them that out of delivery, postal receipt, post 12 minutes.
Delivered.
Out of delivery, maybe delivered today, tomorrow I'll do, madam.
Not today.
Item number 68.
Lordship, I put the petitioner, Lordship. Lordship, I am praying for one day acknowledgement, Lordship.
Why?
Lordship, I have also sent by post, Lordship. I believe today that will be served, Lordship.
Yes, next.
Grateful, Lordship.
Not today.
Item number 69.
Item number 69. You are there?
I am waiting for the.
De facto, who is the petitioner? 69, nobody is there. Next slide.
Item number 70.
Next slide.
Hmm?
Next circuit. Next slide.
Item number 71.
It is here. Next service. Huh?
In this matter, earlier matter was- but I did also If we take time tomorrow, not complicated, I will take. tomorrow.
Very intelligent and strategic.
It's a very innocent. I know.
With the innocent girls. With the
You
innocent.
want to kill me, you
I
kill
thought
me.
as right thing for very innocent.
Very innocent. I don't know anything.
After the film, get us down like can
And we can share I can share with you.
Before mission, there was a delay. Delay has been condoned by the honorable single judge. Now, Millard, the only question which would arise, Millard, is to Millard.
Suit was for?
Suit was Millard for eviction. Millard under the Premises Tenancy Act. Now, if Millard kindly takes Millard from the memorandum of appeal, the judgment passed by the trial court first. Millard, several grounds, Millard, were taken by the
এটাকে একটু খুলে you stitched it with the judgment in this facing this way. এইটাকে খোলো না ছিঁড়ে এইটাকে ইয়ে করে আর নয় আপনার মেমোরে দিকটা আছে এই যে এইটাকে চেঞ্জ করতে হবে এটাকে খুলে সেটা নিয়ে How do you don't check also? নিশ্চয় মামলা দিয়ে ফেলে ওই দিক থেকে মুখ করে গেছে সাউন্ড ছিল তোকে দেখতে হবে এটা ক্যামেরা অফিস The order on affirmation or it is on
reversal.
reversal?
Reversal by the applicant.
Suit was, my lord, dismissed by the trial court, reversed.
বুঝছে? বুঝছে?
Yeah, apologies, your lord.
Yes.
Now, my lord, the only point, my lord, on which, my lord, it was reversed was the question of subletting. The other grounds, my lord, with regard to, my lord, construction, renovation of the premises, my lord, whether the tenant was a default or not, my lord, both the courts, my lord, had a concurrent finding in favor of me. So, lord, I'll only take your lordship into the question of subletting and the observations of the courts below. Now, my lord, if my lord first takes, my lord, the trial court's judgment, internal page 9, issue number 6.
Yes.
The issue was from, my lord, whether the defendant number 1 has sublet the tenanted suit premises to defendant number 2. Now, my lord, the evidence was analyzed in great detail. The provisions were, my lord, considered. Now, thereafter, my lord,
DW1 was the
DW1 was, my
was
lord,
the tenant,
was the tenant.
and DW what is the respondent number 2?
My lord, the respondent number 2, my lord, I'll just, my lord, clarify your lordship, my lord.
Landlord was the plaintiff,
Landlord, my lord, was the plaintiff.
the Manju Sarkar and her son.
Manju Sarkar expired. Her son, my lord,
Very good. Now
remained.
Robindranath Ghosh was the tenant.
Robindranath Ghosh, my lord, is the tenant. Dibakar Shaha, that is, my lord, the appellant number 2, my lord, is the person with whom allegedly the tenant entered into a partnership.
Why allegedly you are disputing?
We are
that?
disputing it. Partnership is admitted, but whether that partnership, my lord, tantamounted to subletting, my lord, that is, my lord, probably would
So
be
you entered into a partnership deed with Dibakar.
with Dibakar and others. There are others also in the partnership.
You have all are impleted.
All are not impleted.
Only Dibakar.
Only Dibakar, because
There
that's
were other partners also.
other partners also. My lord, now in the plaint, my lord, only Dibakar and this gentleman who is the tenant was impleted as parties.
Yes.
Now, my lord would find, my lord, issue number 6, which, my lord, I was placing before your lordship. My lord would find, my lord, that at internal page 10, my lord, the evidence was, my lord, analyzed, and, my lord, subsequently at page 15, my lord would find these, my lord, the findings of the court on the basis of a decision delivered by the Honorable Supreme Court. My lord, at page 15 at the bottom, my lord would find 1987 3 SCC 538 was relied upon. And thereafter, my lord, the learned court proceeded to hold that, my lord, it was not a case of subletting. Page 17, the second paragraph. Thus, based on the aforesaid discussion and observation made by this court, it is held that the defendant number 1 has not sublet the suit premises to the defendant number 2, and that the defendant number 1 is not guilty of subletting the suit property illegally in favor of the defendant number 2. Now, prior to that, if my lord kindly comes back to page 16, my lord would find why the court was, my lord, convinced to hold this, the learned court below. 2 ingredients which the learned judge felt would be required to prove that there was a illegal subletting would be: number 1, the tenant had sublet or assigned or parted with the possession of the whole or any part of the premises. Such subletting or assigning or parting with the possession has been done without
obtaining consent in writing of the landlord. So subletting is on the landlord, but if the landlord proves that a subtenant is in exclusive possession of the suit premises, then the ownership is shifted to the tenant to prove that it was not a case of subletting. Now, in the case in hand, Millard, the question that the tenant, Millard, was in physical possession of the suit premises remained, Millard, uncontroverted. Millard, probably so far as Millard, as I look at it, Millard, there was no evidence or material on record to conclusively come to a finding, Millard, that the tenant was not in exclusive physical possession of the premises. He was in physical possession. He inducted the partners, Millard, on the face of, Millard, financial hardship. Now, Millard, this detailed finding, which was, Millard, on the basis of evidence, was, Millard, reversed by the appellate court, Millard, probably, Millard, on erroneous considerations. Now that I will place, Millard, now what went against me before the appellate court. That Millard would find at internal page 5 of the learned appellate court's order, judgment rather. Millard would take page 19 onwards, para 19 onwards, internal page 6. Para 21 and 22, Millard would find two other decisions were relied upon. 22 is, we are also relying upon this, where the Honorable Supreme Court, Millard, said that whether partnership merely would amount to subletting, Millard, would be a mixed question of facts, which has to be decided on the basis of available materials and evidences on case-to-case basis. Subsequently, the finding of the court is at para 23. Millard, in essence, Millard, the last paragraph would be the line which starts with the at internal page 9. The last paragraph, the last sentence. The defendant number 1 has also failed to produce balance sheet, books of accounts, income tax file, or any other papers or documents relating to the business from which it can be inferred that the partnership deed produced by the defendant has been acted
Where you are
upon.
reading?
Millard, internal page 9 of the learned appellate court's judgment. The last sentence.
9.
Internal page 9.
Fail to show.
Yes. But I'm only showing the most clinching findings. Millard, there are other findings also, but Millard, I'm only placing the most clinching findings. So the appellate court, Millard, took a different view that in spite of the fact that the partnership was admitted, whether the partnership was actually acted upon, according to Millard, the first appellate court, that was not proved.
So what is the point of law?
Millard, the point of law would be, Millard, in my respectful understanding, Millard, in the facts and circumstances of this case, whether the subletting, the partnership tantamounted to subletting which falls foul of section 6 clause A of the Premises Tenancy Act.
Place section 6.
Yes, Millard.
To doubt in West Bengal premises.
Yes, no. Millard, we have, I'm sorry, Millard, we are having two books, Millard.
It's okay, one.
Millard, 6(1)(a), protection of tenant against eviction, notwithstanding anything to the contrary contained in any other law for the time being in force or in any contract, no order or decree for the recovery of possession of any premises shall be made by the civil judge having jurisdiction in favor of the landlord against the tenant, except on a suit being instituted by such landlord on one or more of the following grounds. We are on A. But the tenant has sublet, assigned, or otherwise parted with the possession of whole or any part of the premises without obtaining the consent in writing of the landlord, or the tenant has used the premises for a purpose other than that for which it was let out without obtaining the consent in writing of the landlord. Only on this point, Millard, the
execution case has been filed.
Execution case, Millard, has been filed. The cost for police help has also been deposited, Millard. We are anticipating, Millard, any adverse step at any moment. And that's the reason, Millard.
Mr. Ghosh, there is no, it is a factual finding whether it is an ostensible partnership or it is a real partnership surrendering everything.
Absolutely. Now, Millard, since there
So
is no,
this is not a point of law.
no, Millard, they are probably subject to Millard correction by your lordships. Millard, I'm probably, Millard, I will be held by section 103 of the CPC. Your lordship knows well, Millard, when there is a substantial question, in connection with the substantial question in a second appeal, the court may reappreciate the evidence when there is no concurrent finding of facts of the both courts. Here, Millard, there are contradictory findings of the learned courts below. Millard, kindly, Millard, if
Show us the finding of the learned
yes,
first court as regards your possession.
yes, yes. Millard, yes.
Mr. Rose, what is the point of law? Because
Millard, there is a point of law, Millard. I'll place Millard. Can we take Millard 103 of the CPC ones, Millard, for my satisfaction?
103
Of the CPC, yes. CPC, go ahead.
Yes.
Millard, had there been a concurrent finding of facts, Millard, probably, Millard, I would have
The issue
no
is
case.
whether your occupancy status of the suit premises,
Right.
admittedly, you did not obtain consent. You entered into a partnership.
Correct.
Now this
That's right.
partnership did execution, whether it will tantamount to
Subletting.
subletting.
Yes,
So this this has to be based on the factual issues.
correct.
What is the point of law involved?
Millard, Millard,
Section
kindly,
103.
yes, Millard, 103, Millard.
Yes.
Millard, Millard, the provisions regarding second level starts with 100, Millard. That is not required. Power of High Court to determine issues of fact. In any second appeal, the High Court may, if the evidence on the record is sufficient, determine any issue necessary for the disposal of the appeal. I am, Millard, probably subject to correction by your lordships on B, which has been wrongly determined by such court or courts by reason of a decision on such question of law as is referred to in section 100. So, Millard, if the substantial question today is whether in the facts and circumstances of this case, the partnership tantamounted to subletting, to that extent in a second appeal, your lordships can reappreciate the evidence, since there is no concurrent finding of facts by the two courts below. But had there been concurrent finding of facts, Millard, I would have been out of the court. There is no doubt about it. Since this is a mixed question of law and facts.
Stop. The appeal shall be heard on the
Grateful, my lord.
following grounds. Whether the first appellate court was justified in holding that the respondent number one, not that the appellant number one stroke respondent number one, sorry. Whether the respondent number one, sorry. Having entered into a partnership agreement and having permitted a partnership firm to operate from the tenanted premises, has parted his possession and surrendered his right to occupancy as a monthly tenant and has sublet the premises. Next, whether the purpose behind the execution of the partnership deed was ostensible and having granted permission to operate from the tenanted premises, comma, the tenant has sublet the premises. Stop. Yeah? Premises. Stop. তারপরে একটা দাও। Application being can 1 of 2024. The present application for stay has been filed in connection with the appeal. And, stop. Next para. As we have admitted the appeal, comma, there shall be a stay of operation of the impugned judgment and decree dated 25th August 2023 and 16th October 2023, passed by the learned additional district judge, comma, fast track court, FAST, fast track court, comma, Sodor, comma, Kuchbihar, in title appeal number 1 of 2020 till the end of till the end of April 2025 or until further orders, comma, whichever is earlier. Stop. The appellant ওটা রেসপন্ডেন্ট নাম্বার ওয়ান করবে না, ওটা অ্যাপেলেন্ট নাম্বার ওয়ান, ওই গ্রাউন্ডটা দিয়েছো না? Whether the first appellate with the appellant number one, he entered into the partnership.
Yes, yes, yes. He was the tenant.
He will or the appellants are directed to serve a copy of this order along with the memo of along with the stay application upon the respondent within 2 weeks from date and to affirm an affidavit of service. Stop. When is your circuit in March? After 3rd March, when it is there? জানো কবে?
First April, milord. First April, milord.
আচ্ছা, list the matter for further consideration before the next available circuit bench on 12th March. On 12th March.
Lord,
subject to the convenience of the honorable court,
Lord,
and to file an affidavit of service on the returnable debt.
Lord, subject to your lordship's consideration, Lord, that formal directions for paper books. If Milord,
No, that we will decide, let them
the
come and
honorable
see.
single judge,
Eh?
now it will appear before the honorable single judge.
Yes.
That the honorable single
There
judge
you have
said-
to,
Yes,
we have not disposed of your application.
Right, grateful, Milord,
They
extremely,
will appear.
extremely.
Chalo. So take an adjournment, madam. You have thrice, you have taken adjournment. Justice Banerjee, subject to correction, said that it is such a second appeal where we should hear the other side. When have you served? Give us. No, when have you effected service? Your service effected. This is on 3rd January 2025. Show us that tomorrow is the date before the trial court. What you are submitting, madam? Don't, please don't pressurize us. We.
One matter, my lord.